Good afternoon. It's Wednesday, March 4th, 2026. The Senate Judiciary and Public Safety Committee will come to order. Members, we're going to start with a presentation. Oh, I have to make a brief announcement. By attending this hearing, you agree to adhere to the standard expectations and decorum of the committee, as explained in the written document available with the committee handouts, and any additional verbal instructions I may add as chair. So I have a lot of discretion here. Didn't realize I had that much. All right, we're going to start out with presentation from the Judicial Branch. So we will welcome Jeff Shorba, the State Court Administrator, and I understand Chief Judge Michael Fritz from the 7th Judicial District. Welcome to the committee. Introduce yourselves. Decide between the two of you who's going to go first, and happy to have you here.
Good morning, Mr. Chair, members of the committee. Happy to be here. I'm Jeff Shorba. I'm the State Court Administrator, and you'll be hearing shortly from Michael Fritz, who's the Chief Judge of the 7th Judicial District. So we are happy to present two things to you today. One is our supplemental budget request, and the other is to go over the details of our policy bill. So we just wanted to do a short legislative recap. We wanted to thank you very much for funding a number of different items. Last session, the hourly contract rate for psychological examiners. We are busy working on a new justice partner access, and we received one-time funding from the legislature for that. We appreciate covering the employer share of health insurance and some of our lease obligations at the Judicial Center. And then, although it was shorter than we asked, we appreciated the 0.9% increase for our employees that was funded in 1 year of this biennium. Unfortunately, we were not able to get salary increases for both years, or increases for our judges, or increases to the jury per diem. So just a preview. We'll be back next year to talk about those things. But in the meantime, I wanted to cover our supplemental budget request. We understand there's still uncertainty despite the forecast from last Friday, but our Judicial Council felt there were priorities that we had to include in a supplemental budget request this year. So I'm going to cover the two of them and then ask for Judge Fritz to contribute to those. The first has to do with a safety and security package, and the second has to do with implementation of the Minnesota Paid Leave Program. So, Judicial Branch safety and security is our top priority. The Judicial Council, our judges and employees put this top on the agenda because we are seeing threats on the rise, both nationally and here in Minnesota. We are not any different. Unfortunately, people are coming not only to courthouses and making threats, but also at individual judges' homes, which Judge Fritz will talk a little bit more here in a minute. Recently in Indiana, a judge and his wife had a situation like we had here in Minnesota in June, where someone knocked at their door, they answered the door, and they were both shot. Luckily, they survived, but it was someone who did not want the judge to preside over an upcoming trial and decided this was the way to deal with it. And we're finding that more and more throughout the state of Minnesota. Instead of appealing a decision they do not like, they are making threats and sometimes carrying out some of those threats. So you can see here on the screen, threats are up, total incidents by 47%, threats to a person or property by 85%, and actual disturbances in the court facilities are up 50%. So that's what's prompted us to try to ask for some supplemental funding for safety and security. There are five components to this particular bill that we think will help with the situations that we are facing among our judges, and I'll just briefly talk about those 5 components. The first is personal data protection. We have modeled both this and the second component after what the legislature is doing. So providing ways to get information, personal information, off of the internet. So we have started signing our judges up for this. but we are asking for funding to provide this to our judges and our court administrators throughout the state so they can have the same kind of monitoring and protection that many of you have in the legislature. The second is again modeled after the Senate to provide some reimbursement for home security. I would say, talking to judges, they often feel much more secure behind metal detectors in their courthouses than they do driving home or at their home property, because that's where people are showing up and things are happening even more often than they're happening in the courthouses. So these dollar amounts are ones that we modeled after the Senate. The third is to provide some more staffing within our judicial security unit. We have 103 locations across the state, 3,500 employees and judges, and we have one person who deals with security. And she was actually hired mostly to do policy work and evacuation plans and continuity of operation plans. And what we are seeing now is threats, serious threats, coming in on a daily basis across the judicial branch. And we really feel like we need some law enforcement experience to help us deal with those. We are sending all of them to the BCA Fusion Center, but sometimes it takes a little while for them to get to all of the threats that are going on, because they're also looking at all of the ones that are coming in regarding all of you. So we would love to have 2 positions with law enforcement experience who can provide guidance to our judges and our staff. Because as you know, when some threat comes in, you're wondering, is this serious? What should I do with it? Do I need to tell my family? Do we need to change our plans? All of those questions come up, and we want to be able to answer those as quickly as possible. The fourth component has to do with the Chief Justice, who is the face of the judiciary. Fortunately, our Chief Justice is very outwardly looking, and so she is going, probably, we did a compensation or a compilation of events for the last year, and she goes to probably 80 to 100 public events every year. But while she does so with limited security. And so this request is to be able to contract with probably the State Patrol to have someone accompany her to those events. Usually they're at night, downtown places, parking garages, other kinds of things. And we think this is the minimum we need for the person who heads this third branch of government. It's about $100,000 a year, not a lot of money, but would make a big difference for her safety and security and whoever becomes the next Chief Justice. And then the last is to resurrect our courthouse security grant program. We've done this in 3 other years for varying amounts of money. We're asking here for $1 million of one-time money to go through a grant process again. Counties submit applications. We have a broad range committee that looks at the applications, and the applications do require a 50% match from the counties in either money or personnel time to be eligible for a grant. We had more applications than we had dollars the last time we offered this, and the threats going up are creating a lot of nervousness also among counties that they probably need to shore up their courthouses. So that's the first part of our presentation on the supplemental bill. I'll turn it over to Chief Judge Fritz. You also have some materials, I believe, in your packets from the Minnesota District Judges Association, who have provided information on a judicial security survey they did and their thoughts on and support for this part of the bill. So, Judge Fritz.
Judge Fritz, thank you for joining us here today. Welcome. Just go ahead and identify yourself for the record and your position.
Good afternoon, Chair Latz and members of the Judiciary and Public Safety Committee. As introduced, my name is Michael Fritz, and I have the privilege of serving as the Chief Judge of the 7th Judicial District. The 7th Judicial District stretches from St. Cloud to Moorhead. It includes 10 counties: Becker, where I am chambered, Benton, Clay, Douglas, Mille Lacs, Morrison, Otter Tail, Stearns, Todd, and Wadena. We have 30 judges and 1 referee. I have been a judge for 12 years. Before I was appointed to the bench, I served as the Becker County Attorney for 7 years. Before that, I was the Assistant Becker County Attorney for 13 years. Thank you for this opportunity to speak in support of the Judicial Branch's safety and security request today. And I know Mr. Shorba just went over a few of the statistics with you. I have a few more to share. And as previously mentioned, over the past few years, the branch has seen concerning increases in total incidents reported, and that was 47%. Threats to persons and property increased by 85%. And reported disturbances occurring in court facilities increased by 50%. These percentage increases are alarming, which is why our judicial safety and security request is so vitally important to the safety of judges and their families, court administration, and for the public that enters our courthouses every day across our great state. For perspective, there were 211 incident reports filed statewide in 2024. In 2025, there were 310 incident reports made. That comes to nearly 6 incident reports per week. In the past 2 months, there have been 11 incident reports filed in the 7th District alone. That average is more than 1 per week. And if we continue at the same pace, the 7th District will have over 60 incident reports filed in 2026, which would double our 2025 number. And I should note, when I prepared my remarks, these remarks were already previously prepared, but today at 10:40 a.m., the 7th District just received another incident report. So now we're up to 12. State court administration, as Mr. Shorba has indicated, currently only has 1 person that intakes and responds to the incident reports. In many incidents, individual chief judges are attempting to help with responses, or the individual judge is left trying to figure out measures to keep themselves and their families safe. Gaining 2 experienced law enforcement persons or with backgrounds in law enforcement would greatly assist with threat assessments, threat responses, coordination with law enforcement, training, and emergency planning. In my combined 33 years as a lawyer and a judge, I have never experienced the level of hostility and the number of threats that exist today towards judges and their families. Judges face threats that are more personal and vindictive in nature because the decisions we make most commonly impact on a person's freedom, family, and/or finances. We decide cases and controversies daily where the parties are asking us to rule in their favor. Our decisions can invoke strong emotional reactions, including anger when our ruling is contrary to a party's request. A judge in my district had a litigant in a contested custody proceeding discover where the judge lived and came to the judge's home during the weekday while the judge's daughter was at home. The litigant was recorded on a doorbell camera berating the judge for her decision in that particular case. The child heard it all, but did not go to the door. And fortunately, that individual had left. And I'm sure you can imagine the conversation the judge had to have with her child after that day about safety moving forward. Another judge left in the middle of a judicial conference this past fall immediately after being informed that a litigant in a contested custody matter was asking court administration staff for the judge's address. On a previous occasion, the litigant had been observed in the area where the judge parked outside the courthouse. The judge didn't want his family to be home alone in the event that the litigant learned of the address. And because of the concerning nature of that information and other information that that judge had, he felt it necessary to provide the litigant's identifying information to his child's school bus driver. It was also reported to the school liaison officer as well. Persons asking court administration staff for personal information about a judge, unfortunately, is a common experience or occurrence. Where does the judge park? Where does the judge live? What time does court end at the end of the day? All are examples that I've heard before. In one county, 2 judges have had or have been repeatedly surveilled by drones in their homes. On one incident, the judge was woken up at approximately 2 a.m. by a family pet. When the judge got up and opened the door to let their family dog out, there was the drone 10 feet in front of the door, or 10 feet off the ground, right in front of the door. The drone activity continued on for a number of occasions over a period of time, and one day law enforcement was able to make it to the residence in time while the drone was still there. And they brought with a chase drone. However, due to the size and speed of the suspect drone, they were never able to catch it. Law enforcement reported that the drone surveilling the judge's home was not a toy-type drone that a teenager would have. They estimated the cost in the thousands of dollars. Judges have had their private phone numbers discovered by litigants. One in particular received repeated threats and intimidating comments, like, "I know where you live," "I'm coming to your home," other threats that were involved in that. The litigant, it was discovered, had made multiple concerning, threatening comments in 4 different counties where there was some active litigation going on. There were 5 different law enforcement agencies involved, initially conducting their own investigations in response, until it was discovered that that litigant was involved in all those other counties. Another similar incident, as the one I just described, involved multiple counties, multiple districts, involving 3 different law enforcement agencies, including the FBI. In both cases, an expanded judicial security unit and intake process with a coordinated response would have likely reduced hours of investigations and days of delay. Judges have experienced doxing and threats of doxing. I know I Googled it. I had to figure out what's doxing. Maybe you all know that it is exposing a public official's address or other personal information and sharing it with others. In one instance, due to the nature of the online threats and threats to be at a judge's home on a particular date and time, a date and time that that judge would be away on vacation, the chief of police had removed the judge's mailbox from its post and the chief of police parked his personal vehicle at the bottom of the judge's driveway so nobody could drive up while the judge was away on vacation with the family. These that I shared with you are just a few examples. And I know, as Mr. Shorba indicated, you received the MDJA materials as well in their position paper. There are other disturbing and threatening incidents described in their paper. And I could go on sharing other incidents with you today. However, I'm fully aware that as elected officials, you understand and appreciate the need for and importance of keeping judges, their families, court administrators, and the public safe. The measures identified in our request will aid in strengthening security at critical points, judges' homes, courthouses, and online environments. And I respectfully ask that you support the Judicial Branch's safety and security request. Thank you once again for an opportunity to testify on this very important matter. I'll turn it back to Mr. Shorba to discuss the rest of our legislative agenda.
Mr. Shorba.
So you can see on the screen the cost of the safety and security measures. It ends up in 28 and 29 being entails about $1.3 million a year. The other part of our funding supplemental request is Minnesota paid leave. As you're aware, the program went into effect on January of 2026, and we are currently participating in the program, but we did not receive any funding for the employer share of this program. We are not here to debate the program, but at the end of the last legislative session, there was some funding given to executive branch agencies to help pay for this particular employer share. Our share is about $644,027, and it goes up to 1.2 in 28. So, and beyond. So we are asking to have this funded just like it was in other branches of government. Because right now, we are having to take money from our other essential functions, and we're about 90% people, so that means not filling very, very important positions to try to pay for this program. So that's the second component of the supplemental. We have 7 policy proposals. I will very briefly go over them. I know there are some individuals who would like to talk about some of them. The first is a recommendation that comes from our jury task force. The Judicial Council set up a task force about a year ago to look at jury issues and how to have our juries be more representative of the communities we serve. One of their proposals we brought forward last session, which was to increase the juror per diem. That did not pass. The other is to try to figure out how we can get as broad a source list for our jury pools as possible. So there are 2 components to this proposal. The first, and these are not permanent changes, the first is to try to enter into some agreement with the Department of Revenue to look at tax records. Some states have decided they want to expand beyond driver's license, state ID, or voter registration, and look at tax records to see if that would help us to expand the pool. We understand that there might be controversies about sharing private data with a government entity, but we are just asking for this temporary look, not to permanently change things, just to see, do a little research on whether it would change our jury source pool. The second is to try to gain access to some Department of Public Safety race and ethnicity data that people fill out when they do their driver's license applications. Right now, the only race and ethnicity data we get is when we send out a summons and we ask people to provide us with that data. It's totally voluntary. They do not have to do it. And we think we could gain, again, a little more knowledge if we knew what the Department of Public Safety knows through the Driver's License Bureau. So this will also be going through the Transportation Committee next week. So that's the jury item. Second is to increase the no-fault arbitration limits. They have not been increased in 25 years, since 1991. Currently, the limit is $10,000. We are asking to increase the limit to $20,000. There are no other changes suggested here in the statute that already mandates no-fault arbitration in these type of cases. But what this would do is allow more people to use arbitration to resolve their cases rather than having to come to court. Because once you get over that limit, your option is to come to court, file a proceeding to get into court, and sometimes those take a lot longer than the people who know how to do this, who are fully trained arbitrators. The third is one we have discussed with you before, which is to modernize the way we are doing court notices by publication. Currently, the statute says it has to be in a qualified newspaper. We understand why that probably worked many years ago, but in 2026, we are having a tough time finding qualified newspapers in local communities. And so we'd love to have the statutory authority to publish these notices on our website. We would probably still use newspapers if they were there, but this would give us another option, which we think is totally necessary for due process in 2026. Conciliation court simplification for cases under $2,500. We are trying to put into place what we have for all other civil cases, which is notice given by plaintiffs, not by court administration. This is a simplification. People sometimes wonder, why does it differ? Various case types or various dollar amounts. This would put it all on the same level and would simplify the process for everyone involved. Clarifying notices in divorces. Right now, the statute says that we have to notify Children and Family Services about situations where we have divorces with or without children. The intent was to notify them when it involves children, and we think we could eliminate this. And we've also talked to the Department of Children and Family, and they are supportive of changing this statutory language. Renewal of restitution judgments. If you get a restitution, there is a 10-year limit on that restitution judgment. And so if it's not fully paid off, you need to go back into court and file a new case and ask for your restitution to be extended. We would like to be able to do that administratively to save the victims and others dollars and to make it, again, more streamlined in these kind of situations. And then the last has to do with our Child Protection Council report that was assigned to the Supreme Court. Justice McCaig is chairing that council. They've held listening sessions, done surveys, gathered all kinds of data, and they need a little bit more time to analyze the data and put it together. So we have talked with the chairs of the corresponding committees, and they are open to changing the deadline date from 2026 to the end of the year 2026. So those are our policy proposals and our supplemental budget request, and we appreciate the time, and Judge Fritz and I will be here to answer any questions you have, Mr. Chair.
Thank you, Mr. Shorba. Just in process here, what we're going to do, members, is shortly we're going to have Senator Westlin, who's the chief author of the bill, join the testifier table. But before we get into the nitty-gritty of the bills, if there are any questions for the testifiers, now would be a good time to ask. I do have a question. If you have the information available, great. If you don't, you can provide it to the committee. Do you have the information that was the basis for your projection on the paid family medical leave dollar amount request? I know it's a relatively new program, and there's probably not much experience yet to give a real solid forward-looking projection of how much leave you expect to be requested and granted. What's your basis there?
Mr. Chair, we put an estimate together for MMB before the bill became law and before it actually was in effect. We were asked for that. We were under the understanding that MMB would then move forward with a package to provide funding for all agencies and including the Judicial Branch. So that's where our proposal came forward and our funding estimate came forward based on guidelines that MMB gave us. We can certainly go back and look and see how those fit now, but that's the basis for our ask here. And unfortunately, that didn't happen in terms of a way for MMB to do it for everyone, and we sort of got left out a little bit at the end.
So I think at some point it'd be helpful to, when was that, Mr. Shorba? Was that?
It was probably, well, it was before the last budget session concluded, so probably a year ago or maybe a little longer.
Okay. I think I would find it helpful anyway.
Okay.
To maybe update the analysis
Sure.
based on your early experience, see if MMB has some additional information to share about their experience and projections, just so we are working as much as we can off of current and accurate projections.
Happy to do that, Mr. Chair.
Thank you. Any members of the committee have any questions about the presentation that's already been made? I see Senator Westlin has joined at the table, so we can dive into the proposal as well. Senator Westlin, did you want to make a presentation about the bill ahead of time, or should we just go into committee questions? What would you like to do as the chief author?
I would be happy to do a quick walkthrough. I think that Mr. Shorba has described what's in the bill, but I'd be happy to just go through each section. I do have an A1 amendment, so maybe we should take the A1 author's amendment first.
All right, well, why don't we do this? Let's adopt the A1 author's amendment. First, put it in the shape of the bill author wants it to be in. Senator Westlin moves the A1 amendment. All those in favor say aye.
Aye.
Aye opposed. Motion prevails. The amendment's adopted. Senator Westlin, why don't you go ahead and walk us through the bill? And I think what I'll do then is ask members if you have a question about each section as Senator Westlin's going through it. Let's just address those questions as they come up. And then once we've gone through those questions and the walkthrough, then we'll entertain amendments to the bill itself. Senator Westlin.
That sounds great. Okay, so looking at Senate File 4064, Section 1 is the piece that Mr. Shorba described that requires the Department of Public Safety to provide the Judicial Branch with race and ethnicity data for the purposes of compiling the jury list. Section 2 is the section that raises the jurisdictional limit for arbitration, no-fault insurance arbitration from $10,000 to $20,000. Section 3 requires the Department of Revenue to provide the Judicial Branch with a list of individuals 17 years of age or older who are required to file a return or have received tax benefit for the purposes, again, of compiling and expanding the jury source list. Section 4 is the new Section 4 from the A1 amendment. This has to do with notices and orders, and this does permit the district court to publish their own court notices, orders, and process for judicial proceedings on the Minnesota Judicial Branch website as an alternative to publication in newspapers. The amendment does specifically reference, and it states now, except as provided in subdivision 2 of 331A.03 or section 645.11. That is the language added, and 645.11 deals specifically with published notice and the requirements for publication. Section 5 requires a plaintiff rather than the court administrator to serve the summons in a conciliation court action. Section 6 deals with notice to public authority in divorce or legal separation, and that is only required with children. As a personal note, because I practice family law, I will just tell you that the only reason the public authority needs to know about cases is those that intersect with families that might be receiving public assistance of some sort for children, and so they specifically need notice on only those divorce cases with children. Section 7 has to do with administrative renewals. This establishes an administrative process for a person awarded restitution, that they can renew the restitution judgment without additional filing fee. It must be renewed in the amount equal to the unpaid principal plus the accrued unpaid interest. And those judgments can be renewed until they are satisfied. Section 8 is a new Section 8 under the A1 amendment. And again, this inserts the language regarding published notice and the requirements for published notice. The amended language states where the district court is required by rule or statute to publish notices, summons, orders, or other legal processes of the district court, may do so by publishing on its own website in lieu of publishing in a qualified newspaper under Chapter 331A. Section 9 extends the expiration date for the Supreme Court Council on Child Protection to June of 2027. And then Section 10 extends the availability of an appropriation for the Supreme Court Council on Child Protection from June of 2026 to June of 2027. That's a quick walkthrough of the bill. Basically, Mr. Shorba did describe all of these in his presentation and remarks, but I think I'm happy to stand for any questions.
Senator Kroon, are you holding up your glasses so you can see better or because you want to ask a question? All right. Senator Kroon.
Thank you, Mr. Chair. And Mr. Sorba, I know you talked to me about this, but can you walk me through again? You have two different sections here that talks about compiling the jury source list with race and ethnicity data. One, it looks like from DPS, or DVS through the DPS, and the other from the Department of Revenue. What exactly does compiling the jury source list mean in terms of what would you be doing with this data?
Mr. Shorba.
Mr. Chair, Senator Kroon, we would just be evaluating the data. We are not going to put into effect any changes to how we do our source list yet. What we want to do is take a look at the data to figure out two things. One is when we get a challenge under the Sixth Amendment that somebody does not represent their community on a jury, the only thing we have to do is compare data. So we look at census data, we look at county-based data, but we are limited in the amount of race and ethnicity data we have that would specifically help us in those challenges or tell us we're not doing something right. If we're violating the Constitution, we want to figure it out. So the first one, the Department of Public Safety is going to help us figure out, with additional data on race and ethnicity, how's it looking? We're not going to change how we do the source list or anything until we evaluate. It's a research project to look at this data, but we need to have statutory authority to do it. The second one is sort of doing the same thing, but when we compile the source list, as I said, we look at three things: voter ID, state ID, and voter registration, state ID, and driver's license. Some states have said we can get a bigger pool. Maybe there are some people who pay taxes who don't have those kind of IDs. So we don't know if that's true or not. And we don't want to start changing things until we look at the data. So we want to compare our data under those three things with the data that people have in terms of tax records and see if the pool is broader. These are two research projects, not changing anything. If the committee or others want us to only have access to this data for 6 months or 8 months or something to do the research, I'm fine with that kind of language change if that makes people feel more comfortable.
Thank you, Mr.
Senator
Chair. So, and thank you for that response. So if it's a research project, kind of a preliminary step to a potential second step, maybe, maybe not. But in this preliminary step, would the data actually be used or could it be used for Sixth Amendment challenges?
Mr. Shorba.
Mr. Chair, Senator Kroon, potentially. Depends on what we find. I think obviously we want to do the best we can under the Constitution. So if the data shows that we're doing something wrong, then we're going to have to go back to even more fundamental changes possibly in how we do this. But we want to know. We want to be informed. And that's really what this policy bill portion is about.
Senator Seeberger, you have a question?
I'm just wondering when would be appropriate to offer my A2 amendment.
Yeah, let's see if there are any other questions,
Okay.
and then we'll definitely circle back to that. Yes. So on Senator Westrom, did you have your hand up for a question of the testifiers? Go ahead, Senator Westrom.
Mr. Chair, Senator Westlin, are you done with your walkthrough?
I am.
Okay.
Mr. Chair and Senator Westrom, I did do a full walkthrough of the bill.
Yeah, Senator Westrom, right now, we're just going to focus on questions, and then we're going to see if there are amendments.
Okay.
To offer. We do have one testifier yet to come forward on the newspaper provision as well.
Mr. Chair, for the prior testifier, hearing the drone story and the sheriff's coming out and spotting it and then chasing it, I mean, it's a little bit armchair quarterbacking, but would have it been appropriate and wouldn't have it been appropriate if they would have just shot it down, and would they do that at another time? I mean, it seems like that's probably the way to capture it and figure out whose drone it was, if it's doing what we were talking about.
Judge Fritz, do you want to take that on?
Yeah, Mr. Chair and Senator Westrom, Senator Westrom, I don't know how many responses I've heard to that when I've shared that story about shooting a drone down, but it crossed my mind till I learned that drones are governed as aircraft under the FAA, and shooting an aircraft down is a felony. And so I don't, maybe law enforcement could go ahead and do so, but I don't know that anyone else can do that without violating that provision. That law.
Senator Westrom.
So, Mr. Chair, and it brings up an interesting point, because at what point is it trespassing? Because chemicals floating across from one farm field to the next can be trespassing. I suppose there's got to be an injury there, but that, at what point is fear and trepidation an injury? I would think that's pretty quick. It brings up an interesting point. I mean, could the sheriffs bring it down? Do you know the answer to that? And if they couldn't, something that's 10 feet, 20 feet away, I mean, on the farm, we would have just shot that down. Stray dogs are a lot further away and they get shot sooner than that. So I say that in a little bit of joking manner, but realistically, we should be changing the law. And if somebody's flying an aircraft that close to somebody's home, property, or person, it ought to be able to be captured somehow, and you lose that right. If it's 1,000 feet in the air, I get it, but what is the rules on that for the sheriff to shoot it down? Because here we sit in a mystery and fearful of who or what, and the mind can just start imagining crazy stuff, and maybe it is that bad, maybe it's an alien, but maybe it's not that wild, and maybe it's the next door neighbor. So any thoughts on that? That I would be interested to know if the sheriffs can, if there's somebody that could testify to that. And if they can't, I think it's a law we should be changing here and looking at that in a serious manner in response to what we're hearing from you.
Judge Fritz, while you're writing your opinion on this, can you include whether or not an alien is regulated by the FAA if they're airborne? And give us an opinion also on whether a SAMSA, a semi-automatic machine-style assault weapon, a military-style assault weapon, or a shotgun makes a difference, and we can get into the gun control debate as well. Judge Fritz, wade in if you dare.
Chair Latz and Senator Westrom, I don't want to offer a legal opinion to law enforcement and get myself in trouble. As a judge, I can't offer a legal opinion. And so, Senator Westrom, this is one of those instances, this specific case that I brought up here regarding the drones is one where we would need to have somebody with some law enforcement experience involved as part of our budget request here by getting two involved here. I've learned way more about drones than I ever cared to know about drones as a result of this instance. And I believe, well, as I understand it too, there are limitations on how close the drones can be to a residence. And obviously, all the reported instances that the judges were making were that these were very close up and personal. I guess to the other side of it, I do know that drones, I don't own one, but they do have the video cameras there. And so if you're on camera with the shotgun at your shoulder shooting it down, they may still have the evidence that that's what occurred. But something needs to happen here. It was me being involved in contacting this particular county, and let me just say this, is every story that I shared with you today, I reached out to the judge and I asked if I could have permission so long as that I didn't identify them by name and I didn't identify the county. And it sounded clunky because I kept referring to them by judge and not using a pronoun. I didn't want to have anything out there that would reignite the flames, so to speak. And so another reason why me as the chief being involved with these particular judges in trying to coordinate a law enforcement response, they felt like their hands were tied in this. I did learn that there is, you can buy it's some sort of a security technology, and I think big cities have it where stadiums exist. I think that there was like some professional games or college games where drones were flying, and they felt it as a risk to the public safety, and we're about to close it down. They do for $150,000 or more, you can get that and record every aircraft that goes up and down and be able to real-time their location. But I don't know if this particular county would have the money in their budget to have that.
Senator Westrom.
Mr. Chair, just wondering, is there anybody here from the Sheriff's Association or that could answer a law enforcement question on that, just quickly?
I don't see anyone stepping forward, but I just want to make sure we don't go too far down this road because we do have a testifier and an amendment. I know that's coming, and we're not going to solve the issue of drone security and legal issues here before this committee, unless there's a proposal to fix it in the bill in some way, which I'm not
Well-
sure how you would do that. Senator Westrom?
Well, Mr. Chair, so if the Sheriff's Association lobbyist is watching, maybe they could get back to us with this information and we could have them in. But, I mean, we're hearing this testimony today in the committee and trying to deal with security issues. So that's why I think it's very apropos for us to figure this out, because I don't know about you, Senator Latz, Mr. Chair, I don't think you'd want a drone 10 or 20 feet outside your door at 2 a.m. when you get up to let your dog out that might have been barking because something was alerting them. I wouldn't want it, and I just think we need to dig into this a lot more because it does bring up questions, and at some point, there's got to be a point of self-defense, and if they lost the drone so they can't track down, we've got to figure out a way to track them down. So I'll leave it at that, but Mr. Chair, hopefully we can get some more information, and maybe the CA could reach out to the Sheriff's Department Association, if nothing else, to help get us some of that information.
Senator Westrom, it would be very interesting information to have, and when we have a bill before us that deals with drone regulation, then we can perhaps dive further. But right now, we've got the policy proposal and the budget proposal for the courts in front of us, and that's what we're going to have to keep ourselves focused on. Senator Holmstrom, your question, then we're going to go to our testifier, Sarah Strong, from the Minnesota Newspaper Association. Senator Holmstrom.
Thank you, Chair Latz. I'm just wondering what the path for this bill is today.
Fair question. We're going to lay this bill over for possible inclusion or adjustments, in particular because we have to figure out what our budget authority is going to look like before we can make any final decisions as a committee. And for what it's worth, the second bill on our agenda as well, we're also going to lay that one over. Any other question, or is that the one? Okay. We're going to invite Sarah Strong to come forward then to testify regarding one of the provisions in the bill.
Thank you so much. Good to meet you. Yeah.
Good afternoon, Mr. Chair and members. My name is Sarah Strong. I'm here today on behalf of the Minnesota Newspaper Association, which represents Minnesota's 242 newspapers from the Hanska Herald to the Star Tribune. As you heard, the bill would eliminate the longstanding requirement that important notifications issued by the Judicial Branch be published in newspapers. Instead, those notices could be posted on the Judicial Branch websites. M&A
Ms. Strong, could you pull the mic towards you, please?
Sorry, Mr. Chair.
Thank you.
Thank you. M&A opposes this change. We don't disagree that Minnesotans access information differently today. That's why newspapers have websites. And it's also why state law already requires that notices published in newspapers also be posted on the newspaper's website in front of any paywall so they can be seen and read by anyone. Notices are also placed on a statewide public notice website maintained by the association at no additional cost. In addition, that site is searchable. While there are fewer newspapers in our state than there were 10, 20 years ago, there are still 242 of them, and Minnesotans do read them. 86% of Minnesota adults read their local print or digital newspapers each month. We're confident that public notices disseminated in newspapers and on their websites are more likely to be seen by the parties who are the subjects of these notices, or by others who know the parties and can notify them than notices posted solely on the Judicial Branch's website. Public notices placed in newspapers as a means of alternative service of process has been validated by decades of experience and practice. Making the kind of dramatic change proposed here could raise questions about the legitimacy of service and invite due process challenges. For example, what happens if the court's website experiences an outage? Will a notice requirement still be considered fulfilled if it cannot be viewed? These are important questions to answer as you consider this type of change. Minnesota's Judicial Branch website experienced an outage as recently as February 20th, according to their social media account. And government websites are unfortunately frequent targets of cyber attacks. I'll just stray from my prepared remarks briefly, Mr. Chair. This is the first we've heard that the courts have had trouble identifying newspapers. The association is definitely available to help with that. They help other state agencies with that kind of effort. We also think potentially a better discussion to be had would be in the specific situations in which they are having difficulties, we should be talking about those challenges that they're facing. So rather than eliminating the rule outright, maybe we're talking about some exceptions to the rule in those specific circumstances, and then having a full discussion about what that alternative would look like. So we are maintaining proof of publication and things of that nature. So thank you for your time. We respectfully request that the committee remove the sections regarding public notice, and the association remains ready and willing to work with Senator Westlin and the rest of the committee and the Judicial Branch. Thanks.
Thank you, Ms. Strong. Are there any questions from the committee for Ms. Strong? Senator Clark.
Thank you, Chair Latz. I'm not sure who to ask the question to as a daily paper receiver. I'm just wanting to get a better lay of the land on what this provision costs versus if it were to be online.
Mr. Shorba.
Mr. Chair, Senator Clark, the Judicial Branch pays newspapers approximately $250,000 a year out of our budget.
Senator Clark.
Chair Latz, thank you. And shifting it to online, do you have an estimate of what that cost might be?
Mr. Shorba.
Mr. Chair, Senator Clark, minimal. We already have in-house developers who could develop a place on our website that's searchable. So it would be, we're not asking for any new money for that.
Any other questions on this topic or for Ms. Strong? Senator Westrom.
Mr. Chair, to the judiciary testifier, do you have some examples of areas or counties where you have run into not knowing or not having a newspaper, just for examples?
Mr. Shorba.
Mr. Chair, Senator Westrom, I could certainly provide a map for you of places that do not have local newspapers. I know in my home county of Carver, the Chaska Herald and the Chanhassen Villager are both gone out of business, and so there's no local newspaper. So the problem here is our court administrators have to spend time figuring out, I appreciate what the testifier said here, figuring out, do they have a newspaper? How much is it going to cost? If they don't have a newspaper, is there a website? How much does that cost? They often have to then negotiate with the local newspaper, if there is one or not, how much they're going to pay. Can we do this by an agreement, a check? And if there is not one, then they have to go and decide, do we publish in the Tribune? Do we publish in the Pioneer Press? A lot of times we're left with publishing in Finance and Commerce, which is a legal publication, which I know my grandparents don't subscribe to. So it's a problem. It's a problem out here. And we have tried to work with the Newspaper Association on a way to do this because we think it is a due process issue and people are not finding out about the things they need to find out. And I appreciate the fact that the Newspaper Association has a website, but that would not be the first place I would think to go if I was looking to see whether I had eminent domain issues with a piece of property or my neighbor has. I think I would go to the Judicial Branch website to look for those things. So that's our case. I'd be more than willing to have further conversations. I'd be willing to test out trying this for a year or two where we put something on our website and maybe we put something in whatever papers around saying, go to the Judicial Branch website and look for these kinds of things. And we'll pay the newspaper to put that in there. I'm just looking for a way to move in 2026 to something that is more reasonable and fits the needs for due process. So thank you for the question.
Mr. Chair, if I could just add
Senator
to
Westlin.
that. Thank you, Mr. Chair. And I just want to be clear that these are only notices that are required for the court to publish. So as an attorney, if I have to serve someone by publication, I still have to go through the process of finding an appropriate publication to publish in. And I will tell you, usually people who are being served by publication are not looking in the newspapers where these sort of notices are provided. So I do want to be clear that for me, there's always been a little bit of concern that actual notice is being provided to individuals, certainly in my context as an individual legal practitioner. But once again, this is really only the notices the court is required to publish, that they would be able to do so on their own website. And whenever I'm looking for something court-related, I always go to the court website. I'm going to assume that's where most people go. So this is not undermining publication by everybody else. It's really simply changing the requirement for the courts.
Senator Westrom.
Mr. Chair, thank you, Senator Westlin. And to the courts, what types of publications generally are you covering? I know for probate, I know for title actions, other things, as Senator Westlin's referred to, there needs to be a proof of, or a public notice. What are the things you're covering? And then my kind of coupled with that would be the question of how is the judiciary website the right place, and do you publish on there now as an extra just so you're covering it, even though it's got to go to the newspaper?
Mr. Shorb.
Mr. Chair, Senator Westrom, here are some examples where we are required by either court rule or statute to publish notices and orders. Name changes, restraining orders if the respondent's address is unknown or the respondent is avoiding personal service, guardian conservatorship cases, if there, again, has been avoidance of personal service in those cases, children in need of protection notices, permanency notices for child situations, adoption notices, termination of parental rights summons, and there's a lot of things, as Senator Westlin knows, in family cases where, and I'm not going to go into all of them, where you would need to publish some kind of a notice. So there's a wide variety of statutes and rules that require notice, particularly in cases where you can't find the person or you can't do service. And right now, in answer to your second part of the question, we do not publish anything on our website because we really want to get the statute changed, so we are doing it very legally, that this is the place where people should go. So, thank you.
Senator West.
Mr. Chair, don't you think you could or should start doing that just as an extra practice with the idea of wanting to make sure there's due process and notice? It couldn't hurt for you to do that. And I guess you kind of brought up a point that I was wondering. Is there a pilot project we could try if we're going to do any of this? Because I think newspapers bring up some legitimate concerns as well. And it seems like maybe in a few of those counties or areas where we know there's a struggle, would there be a pilot project that would make sense to start with? Final comment, the $2,500 are changing the service by the court administrator in small claims court. I didn't hear much about that, but seems like that's a helpful thing for lay people that are coming in and don't know much about serving their opponent or the defendant. So what's the rationale for getting rid of that as opposed to raising that up with the small claims cap being raised in recent years? It seems like that should go up instead of down.
Mr. Shorba.
Mr. Chair, Senator Westrom, it was to try to streamline it so that it is all one rule. So right now, if you have a conciliation court claim that is less than $2,500, then the court administrator serves it. If it's more than $2,500, and you're right, the conciliation court limit now is $20,000, then you have to serve it yourself. It doesn't make any sense why they're different. So we're trying to make sure we are as streamlined as possible and people don't look at us and say, this makes no sense. Why is government doing this? Why does it matter if it's $3,500 versus $1,000? So trying to streamline it. That's the reason. And right now, plaintiffs are doing it in cases above $2,500. So we do think they are aware and understand how to do it.
Senator Holmstrom.
Thank you, Chair Latz. Mr. Shorba, the process you talked about was very labor intensive to reach out and find all these locations to post them on. Do you project cost savings in labor on this, or is this just being spread around so many employees that it's negligible?
Mr. Shorba.
Mr. Chair, Senator Holmstrom, we have not done any analysis on that. That would take some kind of a small staffing study to figure that out. We do know it costs us $250,000, so this would be an additional time period for that, but we'd have to do some further study, and I just don't have that information. So it's a good point, very good point.
Senator Holmstrom.
Follow up on that. So my concern is if it's going to be on the Judicial Branch website, I'm as layperson, I'm not an attorney. And when I go to your website, sometimes I get lost. So how prominently will this be displayed? How easy will it be for somebody not used to your website to find it?
Mr. Shorba.
Mr. Chair, Senator, we have certain things that show up on the very front page of our website, especially something like this, where we don't want people to have to do something in the search bar. We want something that is very clear, so we would change our website to have this as one of the things you can click on, just like names of judges or calendars or other kinds of things. So we take it very seriously that this is a due process issue, so we'd make it as prominent as possible.
Thank you, Chair Latz. Thank you, Mr. Shorba.
All right, thank you, Ms. Strong. Senator Seaberg.
Thank you, Chair Latz. I would like to introduce the A2 amendment, please.
Members, the A2 amendment, for the record, like the A1 amendment, it was in your packets. So while you're taking a look in your packets to find it, Senator Seaberger, please describe your amendment.
Thank you, Chair Latz. The amendment would keep the filing threshold for mandatory no-fault arbitration at $10,000 rather than increasing it to $20,000. And I'm happy to explain the basis for my amendment.
Please do.
Okay. In the materials submitted by the Judicial Branch, and I thank you for your presentation, the section that speaks to increasing no-fault arbitration limit describes the process as it should work, not the way it actually does work. I spent most of my 30 years in practice doing no-fault arbitrations, among other things, both as a practitioner and as a no-fault arbitrator. I heard hundreds of cases that were submitted to no-fault arbitration, and my impression is that while in theory it sounds like a really good idea to take these small dollar amounts and submit them to a quick and cheaper arbitration process, that's not what happens here. What it is, in practice, it's a way to really get money from insurance companies. I don't know how else to say it, but when we're talking about increased insurance premiums, this is one way that costs of insurance are going up. A few things I want to point out here. If we're looking at containing the cost of litigation, what we should be really looking at is adjusting the tort threshold at 65B 51 subdivision 3A. If we're really looking at weeding out small dollar cases. In addition, no-fault claims, these no-fault claims are for things like people who go to a chiropractor, for example, and generally overtreat. They will be in a minor car collision and will seek treatment from a chiropractor who will set them up on a treatment regime such as, we're going to see you 3 to 4 days a week for 4 weeks. Then we're going to taper down to 2 to 3 times a week for 3 weeks. Then we're going to taper down to 2 times a week for another 2 weeks until they have gone through almost all of, or a lot of their no-fault coverage. At that point, the insurance company then has an obligation to say, we don't agree with this, and they have to send the claimant to an independent, a doctor for an independent medical examination, which costs between $5,000 and $7,000. Then, when they get the report that says this person doesn't need treatment anymore, only then can the insurance company terminate no-fault benefits, and that is the claim that goes to arbitration, whether or not they should have been terminated in coverage from no fault. Now, no-fault benefits are not the only way to pay for medical treatment. No-fault benefits, however, are the primary insurer, aside from work comp, when it comes to medical treatment incurred due to a car accident. If no-fault cuts off no-fault benefits, the claimant always has their medical insurance to fall back on. In addition, these claims frequently, if not always, go to, they result in a PI claim. And the medical costs are recoverable in that bodily injury claim as well. So my point here is that no-fault claimants are not left without a remedy. However, by the time it gets to no-fault arbitration, the insurance company has not potentially overpaid a claim, but has incurred about $5,000 to $7,000 in IME costs. Now you get to no-fault arbitration, and let's say you're arbitrating a medical claim and wage loss claim. The threshold of $10,000 is only at the time of filing. If a claimant files their no-fault claim and they continue to incur costs, those costs are all properly subject to arbitration, even though it exceeds $10,000. It only applies to at the time of filing. So they go to arbitration. All of this is submitted to the arbitrator. The arbitrators only decide findings of fact. They do not decide questions of law. So to the extent that maybe the no-fault arbitrator issues a decision and oversteps their authority, now they're appealing it to district court for a de novo review. When a claimant files a case, I'd also like to point out that the filing fee for the claimant is $60. The filing fee for the insurance company is $235 per insurance company. So all this to say, Mr. Chair, my experience has been that these are, it's a way to really funnel a lot of money from an insurance company into a plaintiff's pocket who is already going to bring a claim in district court for their personal injury. Most of the no-fault arbitrators are plaintiff's attorneys, and in practice, they end up being a rubber stamping of what the claimant claims. In addition to the outstanding amount, let's just say it's just medical bills. Let's just say it's just chiropractic bills. And let's say that the claimant had $999 or $9,999 in chiropractic bills at the time of filing and kept treating. So now by the time it gets to the arbitrator a few months later, they're up to $18,000. Keep in mind, no-fault benefits, unless you stack, are capped at $20,000 for medical and $20,000 for non-medical. So we're not talking about a lot of money here. But let's say they get to that point. The 9 times out of 10, if you have a plaintiff's attorney, and I don't need to generalize, but this is what I've seen. The plaintiff's attorney will say, yeah, you get all that, and they'll award it. And they'll award the fees and costs against the insurance company, and they'll award the costs to prepare the booklets that go in, which are all just generated. I've received booklets with the wrong claimant's name. I've received booklets with the wrong accident date, the wrong facts of the accident, because people don't pay a lot of attention to these because they know they're going to win. It's a sloppy practice. It is highly biased in favor of the claimant, and I don't think it works the way it should. It simply increases the amount of costs that we all bear as policyholders when it comes to auto insurance. I've looked here at the chart that was provided, that shows the falling off of claims and no-fault claims. And in my experience, this is not because the threshold was too low. What I've seen in my experience as a no-fault arbitrator is that the way that people arbitrate claims is different. For example, back in the early 2010s, 2011s, there were a lot of claims having to do with miscoding of treatment. And that drove a lot of claims. That doesn't happen anymore. And there were also a lot of claims that had to do with timing of submission of bills. But because of some decisions and 62Q, that doesn't happen anymore either. So we're really left with instances where somebody, and it's generally chiropractic care, and it's actually generally some vulnerable populations that I think are sometimes taken advantage of. But in every case, they're represented by an attorney. In every case, that attorney brings this claim eventually onto a bodily injury claim, and all these costs are recoverable at that time. I have a lot of problems with the way this system works. I don't think it works the way it's supposed to work. I think if we're serious about containing costs and insurance premiums, then we need to look at where this insurance money is going, and what we can do to sort of staunch the flow, stop the bleeding on some of these things. This is a misused system, and it's, in my opinion, we should get rid of it altogether. In my 30 years, I have never defended a claim in district court having to do with a denial of no-fault benefits. It just doesn't happen. It just doesn't happen. If the no-fault benefits are denied because you're overtreating, that cost is properly recoverable during your bodily injury claim. So because I think the system is abused, because I think we need to take into account where this money comes from, because I think it feeds directly into the increased cost of premiums that we're seeing in auto insurance, and based on my 30 years of doing this as an insurance defense attorney and practitioner in personal injury and motor vehicle cases, I would ask that we do not raise the threshold and take a better look at how the system actually works. If we're serious about keeping the low-dollar cases out of court, then our attention should really be looking at 65B 51 and the tort thresholds there. Thank you, Mr. Chair.
Senator Westlin to the proposed amendment.
Thank you, Mr. Chair, and thank you, Senator Seeberger. I appreciate the fact that you are probably one of the smartest people in our caucus and that you bring these issues I do have favorites. I appreciate the conversation that you had with me ahead of time. I am in the position as the author of the bill, and I've spoken with the judiciary. I'll let Mr. Shorba perhaps speak to the amendment as well. I do think at this point I'm in a position where unless Mr. Shorba and the Judicial Branch, for whom I am carrying this bill, agree to this, I feel like I'm in a position where I will probably be voting no for the amendment. However, having said that, and as I indicated previously, you have described something that I do think requires us to pay some attention to it. I do appreciate you bringing the amendment. I appreciate all of the information that you've just shared today. I don't practice in this area, and it's all a little foreign to me. And so, again, I thank you for bringing the amendment, and I hope we can continue the conversation. Mr. Shorba, did you have anything to?
Mr. Shorba.
Mr. Chair, Senator Seeberger, thank you for that information. I am not here to defend no-fault arbitration. It's mandatory in the state of Minnesota. We have been tasked with putting the program together, and I do have people here. I don't know how far you want to debate this, but from our No-Fault Standing Committee or the American Arbitration Association, which runs our program, but I am certainly not here to debate whether no-fault is great, bad, indifferent. We are just trying to say if we want to run this program and we want to comply with the mandatory law, we need to increase the limit. There are no general funds that are spent to administer this program. It's administered by the fees that are gathered from people using the system. And as you can see from the chart, maybe I'm wrong about the reason, but a lot of people are not using the system. So you may actually get your wish that the program will go away, because we probably will not find anyone to administer this program if we do not raise the limit and generate some more revenue so that we can actually administer this program. And then we'd have a mandatory law that is not going to be carried out. So for that reason, I only want to deal with the inflationary increase in the costs, and I'm happy to come back with more educated people than I am if you want to talk about the substance, so thank you.
Mr. Shorba, can you or someone with you, maybe from the No-Fault Standing Committee, guide us on the origin of this proposal? What did the Standing Committee have to say about it in terms of their support, non-support, that kind of thing?
Thank you, Chairman Latz and the Judiciary Committee. Thank you. My name is Lindsay Carpenter. I'm a law partner at Mesh, Besher & Spence Law Firm. I'm also part of the No Fault Standing Committee. And for those that don't know, the No Fault Standing Committee is put together by the Minnesota Supreme Court, and it is put up together of 12 practitioners, 6 of which are plaintiff attorneys and 6 of which are defense attorneys. So it's a committee that is evenly balanced with plaintiff lawyers and defense lawyers, and we oversee the no-fault arbitration system. And just briefly to give the background, it was actually July of 2024 where our Minnesota Supreme Court liaisons brought to our attention the idea and the thought that we should move the mandatory limit from $10,000 to $20,000. As we were seeing that increase in small claims court, moving up to $20,000, and the fact that the $10,000 limit was set back in 1991. And obviously, medical expenses have changed tremendously. And the whole system, as far as no-fault arbitration, is to support our courts, not bog down the courts with these smaller insurance claims, and to bring them to qualified no-fault arbitrators, both plaintiff and defense-sided, who understand these type of cases and understand the no-fault system in great detail, and it's a big part of our practice. So in July of 2024, our No-Fault Standing Committee put together a subcommittee to evaluate this idea. I was part of that subcommittee back in 2024 with 7 of my colleagues, both half plaintiff, half defense attorneys, and we looked at it, we went over everything. We presented to the big committee in October of 2024 that yes, we would recommend supporting changing the mandatory no-fault arbitration filing from $10,000 to $20,000. We presented in front of the big committee and it was voted on and agreed that yes, our suggestion to the legislator would be to increase that filing, mandatory filing from $10,000 to $20,000. And this was in the entire room of half plaintiffs, lawyers, past defense lawyers, and I will say that even the voting and the discussion was not polarized one side or the other. It was very effective discussion on how it impacts our practice and how it would benefit and be a positive with those on the No-Fault Standing Committee. That is definitely our recommendation.
Ms. Carpenter, was it? I'm sorry, what's your last name?
Yes.
Carpenter, I got it.
Carpenter.
Okay. Was that a unanimous recommendation then from the Standing Committee?
I believe with the subcommittee, the 7 of us, it was unanimous. And then we presented to the big committee. I believe there were maybe 2 that voted against it, I want to say.
Okay, so we could characterize that as a broad consensus, but not unanimity?
Right, right.
Okay, and was that a recommendation from the committee then to the Supreme Court? And then the Supreme Court looked at it and decided to send on that request to the legislature? Is that how the process worked?
That is correct. At the time, our chair was Judge Chuck Weber, and Judge Weber put together a detailed proposal and letter that went to the Minnesota Supreme Court and our liaison justices, which Justice Thiessen at the time, and I believe it's Justice Hennessy now, has presented, and we are all on the same page as far as Minnesota Supreme Court and the No-Fault Standing Committee in suggesting this.
Okay. Senator Holmstrom.
Thank you, Chair Latz. Senator Westlin or Mr. Shorba, has any research been done into how raising this threshold might affect insurance premiums?
Mr. Shorba.
Mr. Chair, not that I'm aware of, unless Ms. Carpenter has any information.
There was not a lot
Ms.
of
Carpenter.
talk of the impact of insurance premiums going up, and it wasn't data that we had access to. It really is just changing the venue, so I can't really foresee from me and the conversations we had how insurance premiums would be going up because you can always bring the insurance company to district court. but the legislation has been to promote arbitration as a more effective, efficient, cost-efficient for all parties involved, decisions made quickly versus spending a lot of time in court resources. So our position would be that it does not, in fact, impact premiums.
Senator Holmstrom.
Thank you.
Any further questions from members of the committee or discussion? Senator Seeberger.
Well, Mr. Chair, I was just going to quibble with it being cost-effective for all parties involved. It is not cost-effective for the insurance companies. When they're already in it for $5,000 to $7,000, they're paying 4 times the filing fee as the claimant. They're being awarded, most claims are awarded in the claimant's favor, and on top of that, cost disbursements, everything else is awarded against the insurance company. That is where we're seeing bigger hit on the insurance companies. And I do know, Mesh, Besher, and Spence, you are a plaintiff's attorney's firm. So we are, in the words of Senator Eric Putnam, natural enemies. But I do have to take issue that it is not a cost-effective forum for the insurance companies.
May I?
Ms. Carpenter.
Thanks, Senator Latz. I would say that this is just changing a $20,000 claim to no-fault arbitration, where like Judy said it, or Senator, you said that it was about $230 filing fee, to forcing it to district court, where the filing fee is much more, and then there's a lot more expenses at district court versus through the AAA. So that's where I'm saying it is more cost-effective to go through the arbitration process. It's less cost.
So it seems like we're faced with a bigger question about the operation of the no-fault system. But we have kind of an immediate fee-based funding mechanism for the Supreme Court to operate the currently statutorily mandated system. And how do we address all of that? Senator Seeberger.
Thank you, Mr. Chair. Again, I don't think it's the lower threshold that is causing the reduction in no-fault claims being arbitrated. And keep in mind, most people have only $20,000 in no-fault coverage when it comes to medical, and then $20,000 in non-medical. So if you're looking at just a dispute concerning the denial by an insurance company to pay through their no-fault coverage the medical bills, they can't do any more than 20. That's most people's limit, unless you stack, and now we're getting into the weeds. So I quibble with the fact that it is the $10,000 threshold, because that's only at the time of filing. They can litigate as much as they want after that, if bills continue to be incurred after that. And I guess I would, if the rationale here is to try to generate more no-fault arbitration so that the courts can experience greater revenue, then I would really take issue with that that's not what our auto insurance proceeds should be going toward. If there's a funding gap in the district courts, then we need to address that, not prop it up with a system that rewards claimants, punishes insurance companies, and drives up costs for everybody.
We're going to go to Senator Westrom on this topic, and then we're going to bring this amendment to a vote. Senator Westrom.
Mr. Chair, a few questions here. I think the court has kind of indicated why they're picking $20,000 as a number. Wondering if there's a more rational way to pick this. Senator Seeberger's talking about the argument of a lot of no fault is a one not stacked, as she said, which stacking can double, triple, or add as many vehicles as somebody might have on their policy. And so I'm wondering if maybe a percentage, and I guess to the Ms. Carpenter, I think it is, what do you think about a percentage? Right now, 10,000 is 50% of the $20,000 no fault. Would it make sense to do a 50%? So if somebody had stacked 3 vehicles, it'd be up to 30,000, but if they just have one, it'd be at 10,000. Is that a rational basis of maybe bringing this arbitration and then to expedite the time, Mr. Chair, I'm going to kind of couple a couple questions here and see if we can get the response. But secondly, what do you think, Ms. Carpenter, about the response from Senator Seeberger or asserting that this wouldn't save anybody from going to court? The purpose of this, and in some cases at least, is to not get into the court battle because you get a settlement of the injuries, of the wage loss, of the treatments, and the person is put back in as close to the whole shape as possible, and they move on with their lives. But do you agree with that assertion that nobody's resolving their matters and then ending it, or do they all turn into a PI claim in your experience?
Ms. Carpenter.
Thank you, Chair Latz. Thank you, Senator. Well, a few things to address there, I would say, is that the PI settlements, anything that no fault pays is an offset. So just to be clear, there's not double dipping here. That's two separate claims, your bodily injury claim and your no fault claim. So obviously we're concentrating on the no fault claim, trying to make it efficient. As legislation has said, you go to mandatory arbitration if there's $10,000 in dispute. We really support going to $20,000 just with the medical expenses we see trending up quite significantly, obviously, since 1991. And then to address what Senator Seeberger said is, she talked about, well, an insurance company has already overpaid and then they go into no-fault arbitration. That's actually not the case. We have vast majority of cases that we see, both in my practice of 20-plus years and also as a no-fault arbitrator myself for a very long time, that an insurance company hasn't paid a dime. And the injured person pays their premiums and the insurance company's not paying. And then maybe they pay an ER visit and then cut off the benefits. So those are the cases that need to be arbitrated and quickly go above $10,000. You know, we have clients that there's an ambulance bill, there's emergency room, they go see their primary doctor, they do physical therapy, maybe they try chiropractic treatment. So it's just keeping that forum open of arbitration, which is efficient, and that is the ideal, and having that go up to $20,000 given the medical expenses involved. And really, it's a more efficient method, and it is less expensive than going to district court.
Senator West.
And Mr. Chair, Ms. Carpenter, so do you see a percentage of claims, of potential claimants that settle in arbitration and don't bring forward a PI, or is it 100% in your experience or your witnessing that the arbitration is just one thing and everybody brings a PI claim forward after that? And then I'm going to couple another question just to try to be expeditious here. But what, oh no, I lost my train of thought. Answer that question and it'll come back to me.
Then you get one more question, Senator Western. We're going to run out of time today, so just going to try to keep it focused. Senator,
Thanks,
Ms. Carpenter.
Chairman. Thanks, Chairman. Yes, we see both. You see claims where it's just a no-fault claim and you're trying to get your medical bills paid, or you have a bodily injury claim as well. You really see both in our practice. But really, the no-fault claim is completely separate. And like I said, then anything paid is an offset if that person does bring a bodily injury claim. But obviously, going to arbitration, there's no requirement that there is also a PI claim involved. So that's just concentrating on the no-fault claim, and we do see both, where you have that claim or both.
So Mr.
Senator
Chair,
Westrum.
Ms. Carpenter, I think you made an important point there, and it is an offset, so you don't get to collect for your bodily injury and then just get to collect for it on personal injury in a subsequent case if they bring it forward. One of the points Senator Seeberger brought up, and that was my second point I was going to bring up, is she talks about the $5,000 to $7,000, the insurance company. I think there's a whole lot more we should iron out here, but it's the $5,000 to $7,000 maybe should be folded into the benefits rather than everybody fighting for such small amounts of money, Senator Seeberger. So maybe we could come up with a way that the arbitration happens before you spend $7,000 fighting the claims that are, many cases, obvious. But, I mean, most of the IMEs, the independent medical evaluations, which aren't so independent in my experience, do cost you thousands of dollars to get the right doctor to say that this isn't an injury. And so, to me, the system would be more efficient for both sides if you'd have some of this arbitration at 10,000 or some other number before the insurance company has to spend $7,000 just to go to arbitration, and now you're at 7,000 plus the 10,000 or whatever the number is. Ms. Carpenter, I guess I'd put you on the spot and ask you for thoughts on some sort of system that would not have everybody spending thousands and thousands of dollars to fight over such peanuts in the first place, because I think you'd have a system that would generate more content outcomes on both sides of the equation.
So, Ms. Carpenter, I'm going to give you 30 seconds, and then we're not going to have a whole debate here about reforming the no-fault system, because that's not what is before us in committee here today. Ms. Carpenter, and then we're going to go to a vote. No further questions after that. Ms. Carpenter.
Thank you, Senator Latz. I guess I'll just briefly say, with Senator Seeberger saying $5,000 to $7,000 on these IME doctors, they're choosing what doctors they hire. They're choosing what they're willing to pay, and they've set up that system where these IME docs are making $7,000. That's not the fault of the injured party paying premiums to their own insurance company.
Senator Seeberger, final comments as the author of the amendment before we vote.
Thank you, Mr. Chair. If we leave it at $10,000, the claimants still have a venue to pursue these claims. It is if there's an emergency room visit and a visit with a treating physician and a couple rounds of physical therapy, boom, your $20,000 in medical is gone. That's not what's being arbitrated here. What's being arbitrated, again, are the overtreatment cases, the 50 visits to a chiropractor on a minor rear end collision. It's the things where there is a case of overtreatment. That's what gets arbitrated, because those are the ones that are denied. They still have a forum. Again, anything that's incurred over the $10,000 limit at the time of filing. And by the way, if they have more than $10,000 in bills at the time of filing, they can just waive whatever's above it and continue to incur bills, and all of that is subject to jurisdiction too. I just don't think we should open it up by increasing the threshold to $20,000, which is the limits most people have on medical no-fault insurance, to encourage more cases, to make our auto insurers fund shortfalls in other areas. Thank you, Mr. Chair. I would urge a yes vote on the A2.
We're going to have a vote now. Senator Westlin, did you want to add something? You grabbed the mic there. All those in favor of the A2 amendment signify by saying aye. Aye. Opposed?
No.
No. The chair is in doubt. I'm going to ask people to raise their hands. All those in favor, raise your hands. All those opposed, raise your hands. There being 5 in favor and 5 opposed, the motion is not adopted. The amendment does not prevail. Is there any further discussion or questions about Senate File 4064, keeping in mind we have 3 more bills we're going to hear today before we adjourn committee, so we'll be here until they're done. Senator Limmer.
Thank you, Mr. Chairman. Senator Westlin, if I could bring your attention on the bill to page 3. This is the disclosure to the Judicial Branch on lines 3 through 7, where it says Commissioner must disclose a list of individuals, and now we're recognizing 17 years of age or older and other information. Do you know what classification of data this would be? Would this be public data, or would it be considered private? I don't know.
Mr. Chair and
Senator Westlin.
Senator, I do not know, but I do know that there is an issue that has been raised and brought to my attention as I've been sitting here regarding this issue. My understanding is the bill is going to be laid over, and this is something that will have to continue to be worked on.
Mr. Chair, would council have an opinion of what this data would be, classification of data?
Mr. Chair and members, I'm checking the statutes. The tax statutes are sort of a little codified a little bit differently than Chapter 13, so I have to get back to you.
Mr. Chair, the reason I bring
Senator
this
Limmer.
up is that we're now dealing with minors and their age and date of birth, address, where they reside, and if available, race and ethnicity. So I would be concerned whether or not this is considered private data. It should be. And I'd like to talk with Senator Westlin later or council, and we can get a better definition before it comes back to our committee.
Yep.
Thank you, Mr. Chairman.
Any further questions or discussion before we lay Senate File 4064 on the table? Seeing none, Senate File 4064 is laid over. Members, we're going to go to Senate File 4067. I'm the chief author. We'll hand the gavel over to Vice Chair Boomer Vubatin. And I'm hoping this goes quickly, members, so we can keep moving the agenda. Oh, and just so you know, the intent is to lay this bill over, and we'll take amendments, if any, when it comes back before us as part of our budget process. I bet you will. Did I lose the courts? Courts budget, where'd they go? I seem to have lost the courts. Let me step in the hall and see if they still want to present. We did cover it. You guys want to, Vice President, for the budget question as well? Yeah, formally, it's a second. Oh, nice job. Soon. Madam Chair.
Senator Latz, when you're ready.
Members, this might go very quickly because we've already had the testimony about it. Senate File 4067 is the supplemental budget portion of the court's requests. And we've already heard the testimony on it. Basically, it's the Chief Justice Security, it's the grant program, and it's the safety and the paid leave money broken down for the three different components of the court system, the Supreme Court, the Court of Appeals, and the district courts. We're available to answer any further questions that haven't already been addressed in this process.
Senator Holmstrom.
Thank you, Madam Chair. Senator Latz, I don't know if this question is much of a comment, but I have concerns with the idea of covering the paid family medical leave gap. I definitely agree with the idea of bolstering security, but you know, Minnesota businesses are looking at us, putting this mandate on them, and I think as a business owner, I question, well, nobody's coming to save my day. This had to come out of my budgets, and I think that it's disingenuous of us to look at Minnesotans and say, well, rules for thee, but not for us.
Senator Latz.
Madam Chair, I actually take a somewhat different approach to that. For state agencies, in this case, a state-funded independent branch of government, all of their expenses are a matter of public obligation. And while I think we can prioritize between expenditures, we don't, I think we have less grounds to do that at least to some degree, when it comes to the judicial branch, because they're an independent branch of the government under the Constitution. Also recognizing that these additional expenses that were not forecast and projected in the budget that we passed in the first year of this biennium, if it doesn't come from us, it's going to come out of the 85 or 90% of the courts that are personnel, which means it's going to be interpreters cut, it's going to be forensic psychiatrists cut, it's going to be, you can't cut judges, so it's going to be court personnel cut, which means justice is going to move more slowly. The courts are going to have to pay for the mandated paid and family medical leave. The question is, out of whose hide? It seems to me it's a public obligation for all the public agencies. Right now, it's the courts that are coming to us right now seeking the supplemental. We haven't received a supplemental budget request from the other agencies under this committee's jurisdiction. If we do, I think we evaluate that on its merits. But I think we have an obligation to cover these expenses unless we want to make it harder for people to get justice in our justice system, which I think would be the practical consequence of asking the courts to take these obligations out of their other expenditures. And keep in mind, the other expenditures also are, for the most part, I think, constitutional obligations to meet the due process requirements under the Constitution. So a person who shows up in court needs an interpreter but doesn't have one there is not getting due process because they can't participate fully in the justice system. A person who comes in and has a Rule 20 component to their criminal defense is not getting due process if they can't get a forensic evaluation to determine whether they are of sound enough mind to participate in their own defense, or secondarily in a Rule 2002, if they can successfully avail themselves of a mental illness defense during the commission of the alleged crime. You know, if they can't meet a speedy trial demand, then justice is delayed. Constitution requires a speedy trial demand be made. Or, as we just saw in a recent case in the federal courts, there's a risk that the case gets thrown out with prejudice because the person was not granted their trial within the constitutional requirements of speedy proceedings. So everything that happens in the courts is a matter of constitutional significance and causing whatever the number turns out to be, and will get updated per my earlier request to try to nail the number down more specifically, but causing whatever that amount is to come out of other parts of the budget really could lead to constitutional impairments in the justice system. So of all of the agencies that this committee funds, to me, this is the one that's most important, that we cover this with public funds. Setting aside, and I understand the point that you're making about private businesses picking up the costs related to that. I understand that. I'm a private business owner myself.
Thank you.
Senator Gruen.
Thank you, Madam Chair, and I actually agree with both of you on this one. I do think it does have that appearance of, we'll just take care of ourselves. Well, the average business owner is left to pay for it however they can. However, I do agree with Senator Latz in the sense that this should be the top priority if we're going to pay for it, because it is a co-equal branch of government. And quite honestly, the court should have had priority on this over any of the other agencies in the end of the session agreement last year. None of the agencies should have got this paid for before the courts. Because the courts are not just another agency, they're a co-equal branch of government with constitutional considerations. So that's just my pet peeve about how last session ended and how the courts got the short end of the stick on this issue and in a lot of other issues as well. But you're right that somebody does have to pay for it. And this, you know, in this sense, if we don't do it, it could mean, and probably would mean, cuts to jobs within the judiciary. And we don't want that because it could raise constitutional concerns. But on the other hand, it just goes to highlight that those cuts to jobs are going to be happening in the private sector too, and that the legislature needs to be very sensitive to that as well. So thank you, Madam Chair.
you have any final comments, Senator Latz? Okay.
Madam Chair.
Senator Westrom.
Madam Chair, just to that same point, Senator Latz, while I agree with some of your basis and things that have to be done quickly, I'm not sure that we should always bail out government if a ill-thought-through policy is shoved through by the legislature, and then we bail out just the government entities and stick it to the taxpayers, which many of them are small business owners, as you indicated too. And so there's a bigger problem here. It's not the court's fault, but we should be more deliberate and look at the long-term effects when we put in policies. And when these were raised, your party ignored them as if they weren't going to happen. And here we are now bailing out government and not the hardworking taxpayers by covering their expenses and saying, business owners, too bad, just keep paying your taxes and pay more. And if you go out of business or have to lose employees over it, we don't really care, because that's kind of the message we're sending them to it. Where if government had to do the same fiscal constraints or shrinkage and find deficiencies, and the other agencies we covered last year were probably improperly put ahead of the courts. But this is kind of a problem of the Democrats making. And so I have a little frustration that we're going to stick it to the taxpayers and say, too bad, but we're going to take care of the government entities, which always seem to be taken care of. And that's very frustrating. So I just wanted to share that perspective so we kind of have the bigger picture here of this smaller fix, but just another fix that helps government and private business owners and taxpayers that pay our dollars that we have here are left to fight on their own.
Madam Chair.
Senator Latz.
Senator Westrom, when we bring this to a vote later this month probably, you'll have a chance to decide whether to stick it to the taxpayers or stick it to the courts and the Constitution. I have nothing further, Madam Chair.
All right. With that, Senate File 4067 is laid over, and we'll move to Senate File 3804, Senator Rust. And I know there's a number of testifiers for your bill, Senator Rust. You can have the first two come forward as well.
Thank you, Madam Chair. I'm going to make a comment about 4064 and for Senator Limmer. 270B is in the jurisdiction of the Tax Committee. And if anything in 4064 comes out of the Judiciary Committee, we have requested that the bill come to taxes. And I had, the bill that I had withdrawn and returned to author today was this exact same language, and the Tax Committee will not be considering it. So if it does come over, we will remove the language. Madam Chair, or Mr. Chairman,
Senator Rust, to Senate File 3804.
3804. Thank you, Mr. Chairman. Senate File 3804 involves a lot of reactions, as I understand it, to a particular court case from a few years ago, but is a basic disagreement on what kind of information that is non-public affecting or referring to businesses, as I understand it, not humans, is available in property tax proceedings, and who is it available to? And the counties and the assessors collect information and use it, as I understand it, use it in determining the market value of a piece of property, and the data that they collect is non-public. However, they are simultaneously, as I understand current law, not allowed to share most of that information. And so the court case, Oracle, a few years ago, those notions were challenged. They were decided in the favor of the county's interpretation. But this bill wants to put a slightly different emphasis on the kind of information that is required to remain non-public, but how can the individual taxpayers understand the basis for which the value of their property is used? How can they dispute it if they do not have the same kind of data as they are challenging the assessor's evaluation and setting of the market value? But on the other hand, the information has, or the data has certainly some protective issues with it. This is, I think, I'm saying this from my own non-lawyer perspective, but I believe that the issues within 3804 are extremely familiar to you, Mr. Chairman, in particular. But I also am very appreciative that, as well as yourself, Senator Kroon, Senator Limmer, and Senator Westlin, are co-authors on this bill. So the testifiers are going to, some will be supportive of the approach that's taken in the bill. Representatives from the counties and the assessors associations are opposed. I believe, so that's what I see in the first two sections. Some people call this the August 1st rule, and that particular provision, which is paragraph B on page 4, there's the date of August 1st is supposed to be the deadline for the information that is to be used to make a determination in tax court, and then if it's challenged to the Supreme Court. But occasionally there are errors that are made, and currently there's no recourse. But in that paragraph, it is suggested that there be a 30-day period wherein any kind of mistakes or deficiencies or et cetera are cured and corrected. So, Mr. Chairman and members, that is my basic understanding of what this bill does. It particularly deals with, and I'm sure this is familiar too, there are 4 ways of determining the value of a property for taxation purposes. One is looking at, well, if it's homes in particular, the sales ratio is looked at of properties in your neighborhood that are sold during a particular year, and the Department of Revenue or assessors makes a determination of the value of your home based on that kind of comparison. The other, for commercial properties, has to do with income-producing properties. How do you capitalize that value and then assign a market value that you then have as a taxable value? So those are, I think those are the two things that we mostly, at least in the tax committee, that we have questions about when any kind of changes are suggested. And that's what I know, and I would appreciate your listening to the testifiers on both supporters and opponents.
Thank you, Senator Rest, who just scratched the surface on what she knows. All right, we're just going to take this in the order that I have for the testifiers in front of me. We're going to start with Lane Thor, Principal on Real Property Tax from, I believe it's the Ryan Law Firm. Mr. Thor, go ahead and introduce yourself formally for the record and proceed.
Mr. Chair, members of the committee, my name is Lane Thor, and just like Senator Rest, I am a non-attorney, but I do have 20 years of practical experience in Minnesota property tax valuation, administration, and appeals. I've served as a licensed assessor and now as a practitioner representing taxpayers across the state of Minnesota. In my current role as a principal for Ryan, we are a global business tax and tax technology firm with an office here in Minnesota. I'm here today in support of 3804, and at its core, the question before this committee is simple. First, should litigants in property tax appeals have equal access to relevant information? Second, should the outcome of a property tax appeal be determined based on the merits of the case rather than procedural perfection? The answers to both questions should be yes. First, the bill utilizes protective orders to safeguard sensitive business information while allowing both parties equal access to data to evaluate the property value. When parties have access to the same information, disagreements narrow and negotiations become more productive. Second, the bill addresses procedural issues in 27805, Subdivision 6. Over time, Subdivision 6 has evolved into a strict procedural requirement that can end a case before the court ever reaches the central question of valuation. There's also a tension within the statute itself. Subdivision 1 directs the tax court to, and I quote, disregard technicalities that do not affect the merits. Yet, Subdivision 6 will dismiss petitions for exactly these types of issues. In closing, 3804 restores balance. Property tax cases should be decided based on the merits, not on procedural technicalities or the prevailing party in a battle over access to information. For those reasons, I respectfully ask for your support. Thank you, and I'm happy to answer any questions.
Thank you, Mr. Thor. And if you want to go ahead and have a seat back in the observation seats, we'll hear now from Thomas Wilhelmy from Ryan Law, and we'll welcome Rebecca Holshaw to come forward and take the other testifier seat. Or Patrick Chapman. Oh, there's Ms. Holshaw. Okay, Mr. Wilhelmy.
Thank you, Mr. Chair, Madam Vice Chair, committee members. My name is Thomas Wilhelmy. In June, I will begin my 49th year of practicing in the area of real property law and property tax law. I was lead counsel in the Oracle case and in virtually every other case cited in the background to Senate File 3804. The protective order provisions of Senate File 3804 appropriately address the interests of third parties regarding their proprietary non-public data. If a county relies upon the same non-public data under Oracle, that data becomes part of the public record with no protections. In my experience in the few years just since Oracle, without the amendments to Senate File 3804, the full process described by Minnesota Statutes 1303 Subdivision 6 is unnecessarily expensive and time-consuming for every taxpayer and the court, and does not result in any substantively different outcome from the process recommended by Senate File 3804. In Oracle, the tax court found it violated due process when Hennepin County refused to provide relevant information in response to legal discovery on the ground that it was information protected as non-public under Section 1351, and then the same county officers used that same information in their trial appraisal, which made the public that same information. In Oracle, the Minnesota Supreme Court held that Minnesota Statute 27805, Subdivision 3, permits assessors' records to be admitted at trial inclusive of any non-public data that they may contain. In his concurring decision, Justice Thiessen focused on the conflict of interest created by the county's dual role as, one, the custodian of sensitive information of property owners necessitated by its duty to fairly assess taxes, and two, a party to litigation over the assessment and the decisions it makes in individual cases. Note the duty is to fairly assess and not to maximize property tax revenues. The issue focused on is not only the non-public information which the county wishes to rely upon at trial, but also on the highly relevant information which the county wishes to withhold, since it leads to a value conclusion which is contrary to the county's intended outcome. Justice Thiessen reasoned that the decision in Oracle does not settle the issue. If anything, it adds to the confusion, concluding that it's time for the legislature to step up, engage with all the stakeholders, and devise a more nuisance solution to the conflict. In conclusion, one of the arguments you often hear is that the counties decrease property taxes on residential property by increasing the tax burden on commercial and industrial or business property. Please bear in mind that the owners of residential property frequently work for or own the business which occupy business property. If the business property taxes exceed a fair value, that diminishes the funds available to that business to pay existing salaries and for creation of new job opportunities. I urge all the legislators to carefully consider the effective consequences of all theories proposed to them on this bill. I will make myself available for any questions which anyone may have. Thank you very much for your time and attention.
Thank you, Mr. Wilhelmy. And if you go ahead and have a seat then, we'll invite Patrick Chapman to come forward and take your seat, and we'll turn to Rebecca Holschuh.
Good afternoon, Chair Latz and Senators. Thank you so much for allowing me to testify today. My name is Becca Holschuh. I'm an assistant Hennepin County attorney, and I lead the tax court practice in Hennepin County, where we defend approximately 2,000 new tax court appeals every year. I'll start by saying the county shares the committee's goal of protecting sensitive data and using data responsibly. Additionally, while it shifts the burden, the county agrees to the safe harbor created by Section 5 of this bill. Many counties, including Hennepin, already provide a deficiency notice as part of their practice. The remainder of the bill would weaken, not strengthen, privacy protections for commercial real estate data and hurt the assessor's ability to value property at market value, which is the statutory mandate. This bill does not protect the data. In practice, it does the opposite. County assessors collect market data in the first place in order to accurately value income-producing property under widely accepted appraisal practice. Actual data is essential to be able to value the property at market value, the statutory mandate, and ultimately ensure property taxes are fair. The data about individual investment properties that the assessor collects has long been protected by the Minnesota Government Data Practices Act, Section 13.51. This bill would effectively replace that consistent statutory protection by releasing all of the data to competitors and only protecting it with a case-specific protective order. Litigants in property tax appeals, who are most likely to be interested in the non-public data the assessor collects, will have access to all of that data, not just the data the county uses to formulate its value in the case at hand, which is the practice currently. The consequences of this bill are several. It would effectively make counties a clearinghouse for commercial real estate data, similar to other commercial services. This may require additional funding. It would discourage taxpayers from appealing their property taxes because the data they provide would be readily accessible to competitors, other folks who file property tax appeals. Finally, this bill doesn't solve a fairness problem. There would be no parallel requirement that the petitioner's experts share the universe of data accessible to him or her, including the data they didn't use in support of their appraisal. Under the current procedure, both parties are only required to disclose the data they rely upon to support their appraised value at trial. Finally, another provision of this bill requires the tax court to issue protective orders to data used at trial. There are policy and constitutional considerations to sealing a courtroom and trial record, but setting those aside, the information in the assessor's possession remains protected by Section 1351. Layering a protective order with potentially inconsistent terms is not workable. We have thousands of cases and need to treat data uniformly. The protective order could even interfere with the assessor's ability to use data internally to value properties equally. Again, the assessor is collecting market data and intentionally aggregating it to measure market value. It's not possible to assign the protections of a different protective order to each number in a data set. In sum, this bill removes the existing statutory protections for data and replaces them with something far less effective that allows anyone who files an appeal to access a huge amount of data. But even more concerning to the counties from a due process and fairness perspective is the bill's language requiring the tax court to issue a protective order that may govern the county's data instead of relying on the Data Practices Act. Thank you, and I'm happy to take any questions.
Thank you, Ms. Holschuh. We'll turn to Mr. Chapman.
Thank you, Chair Latz. My name is Patrick Chapman, and I'm the Ramsey County Assessor, and I'm appearing on behalf of the Minnesota Association of Assessing Officers. Thank you. I want to thank Chair Rest for our meeting yesterday. She's been a friend of the assessing community and a stalwart defendant of our professionalism and our highest integrity standards. Fair and equitable assessments is the cornerstone of the Minnesota property tax system. The protective orders would limit the employees to have access to the data. This would severely handcuff assessing jurisdictions, as protected data would not be able to be considered for any other purposes outside the tax appeal that it was provided for. The protective orders would make it impossible to provide accurate, fair, and equitable assessments if the data therein could not be taken into consideration when setting our values. Taxing jurisdictions would have no other source for actual market data that could be taken into consideration for their daily work, including setting fair and equitable assessments for tax petitions. Defending appraisal reports when relying solely on general market data from subscription services would not have actual market data. This is a recipe for disaster at trial, as the tax court requires us to have this information. Taxing jurisdictions would not be able to satisfy the requirement for writing the component of the supporting appraisal reports. Any rental expense data received would automatically become protected. This means the data is no longer permitted to be considered for any other purpose outside the petition which is received. Not all taxing jurisdictions would be forced to hire fee appraisers, but many would to try to support their valuations. This cost would be typically in the several $1,000s per report. Larger in some jurisdictions, it could reach up to $1 million for some jurisdictions to hire outside appraisers to defend our assessments. If a taxing jurisdiction can no longer internally support their assessments by writing their own appraisal reports due to protective orders, in addition to taxpayers covering the cost of hiring private fee appraisers, there will be a tax shift away from commercial properties to the residential properties. I appreciate the opportunity to outline our concerns at the time you've offered to me, and I hope that we could work together to come up with a reasonable solution that meets both sides of this issue. Thank you very much, Chair.
Thank you, Mr. Chapman. All right, we will now turn to discussion from members of the committee. While we've got the two testifiers who are sitting there at the table, are there any questions for them? Not seeing any right now. Thank you, both of you, Ms. Holscher, Mr. Chapman, for your return to your seats. Any discussion or questions from members of the committee?
Mr. Chairman,
Senator Rust.
may I comment? It amazes me how what otherwise would seem to be a very dry issue becomes extremely emotional between the taxpayers, the people who are representing the taxpayers, and the people who are representing the counties and the assessors. And in one, and the bill is supported, by the way, by the Chamber of Commerce, BOMA, NIA, et cetera. But the language in one letter talked about this bill being severely cumbersome and severely handcuff assessing jurisdictions, and a recipe for disaster. Okay, got that? And with regard to his testimony, that the taxing jurisdictions would be forced to hire appraisers, and it could be upwards of $1 million that the taxpayer would have to pay in order to avail themselves of the same level of data gathering that is available currently to the counties and the assessors. I just find that heat of that emotion is, to me, is surprising, I must say. I thought these, I didn't realize the passion about protection of data, and then who has the right to make decisions based on that data that they refuse to share with the counties who are making the decisions about what value is going to be subjected to the property tax itself. So it is not a simple issue, and the fierceness of the opponents and proponents is of great interest to me. Thank you, Mr. Chairman.
Senator Rust, if this had been an easy issue to resolve, it would have happened a few years ago when it first emerged here at the legislature. It's been around for a while. I think you found your swan song. This will be your crowning achievement of a productive legislative career when you retire at the end of this session. Any other questions or comments from members of the committee before we move to a vote? Senator Kroon.
Thank you, Mr. Chair. I think this is it's a hard balance. I think that's why it's complicated, but I mean, you have to balance it somehow between fairness and privacy. And so I think it's a good attempt. I think the fundamental problem is, about proprietary information is that's what's used to formulate property taxes. And maybe that's not the best thing we should be using, but that's what we have. And I think the court is charging us with coming up with a new way of balancing this. And I'm not an expert in this area, but I think it seems like a reasonable effort. Thank you.
Any further discussion? Senator Westlin.
Briefly, Senator Rest, I'm too not convinced that this is the right way to figure out property taxes. Property taxes really should be about building costs and location, and how much somebody's making in the building is income tax. And so I think this is probably still the wrong direction. But I realize you've put a lot of work into it, but I think that's the inherent problem. We're probably looking at this the wrong way.
Mr. Chairman.
Senator Rust.
Actually, the third way of determining the value for tax on business property is indeed the cost way. what are the costs that go into the construction of a building? So it's the sales ratio for homes, the capitalizing on the rents for income-producing property, and then a third way that we don't often see, but with new construction would be how much did it cost to build the building, and then for the initial valuation on which the property tax is assessed.
Seeing no further discussion, Senator Pappas moves that Senate File 3804 be recommended to pass and be re-referred to the Committee on Taxes, where I'm sure it's going to have a favorable consideration. All those in favor say aye. Aye. Opposed? Motion prevails. Senator Port, Senate File 3596. All right, members, Senate File 3596 is being distributed. As you know, this was added on to the agenda. It came from the Taxes Committee this morning and is expected to move on to the Finance Committee when we are done with it. There's also an amendment in there, the 824 amendment, that we'll be considering as well. We have limited jurisdiction on the bill in terms of what brought it here. Which is on page 3, line 10. There's a data practices provision.
Mr. Chair?
Senator Limmer.
Mr. Chair, I had a question about process. This bill had a hearing in the Tax Committee this morning. It's now here for secondary jurisdiction. But don't we have a rule for a 3-day notice before a bill comes before it, unless there's a impractical reason why the bill should be rushed in this manner? Could I understand the reasoning why we have the bill just mere hours after it passed the Tax Committee?
That is in fact a rule, right? So, Senator Limmer, you're correct. There is a rule that addresses a 3-day notice whenever it's reasonably practical to give or practicable. In this particular circumstance, because of the nature of the remedy or of the problem that it proposes to remedy, there's a great deal of urgency. And so we've opted to move this along more quickly as well.
Mr. Chair,
Senator Limmer.
Could we have an explanation of what the emergency actually is?
Senator Limmer will give Senator Port, the chief author of the bill, the opportunity to describe the bill generally, to explain the urgency, and then we'll address the data practices provisions which bring it to this committee. Senator Port.
Thank you, Mr. Chair. Members, I'm glad to be in front of you today. This is a bill for emergency rental assistance. It proposes that we move $40 million through counties to provide emergency rental assistance. Mr. Chair, in speaking with the Greater Twin Cities United Way, Legal Aid, and Homeline, all three of whom take calls from tenants as crises are beginning to pop up, they have seen between a 60 and 80% increase in calls over the last 3 months regarding rental assistance and the need for rental assistance. They are expecting a significant jump in eviction filings starting here in March and continuing because there is no more rental assistance available. The counties have gone through their quarters allotment of rental assistance. And right now, communities are stepping up and have paid through mutual aid significant portions of rental assistance, but that is unsustainable. And we are facing an eviction crisis in Minnesota. We know it is far more expensive to the state once a family has reached homelessness to get them back stably housed than it is if we prevent that eviction in the first place. It is less costly to landlords to be able to keep a tenant that they have not had problems with, who they're able to, be made whole from rental assistance. And so our goal is to provide this $40 million in emergency rental assistance as quickly as possible to stave off this eviction crisis.
The provision on page 3, line 10, data practices.
Yes, thank you. Page 3, line 10 through 313 is the portion in front of this committee. It just holds that in this section is private data, that it's not public data, which is common with programs like this, but it can be disseminated to verify that the applicant is eligible to receive this assistance.
Any questions from members of the committee relating to the data practices provision here? Senator Kroon, then Senator Westrom.
Thank you, Mr. Chair. I know that the data privacy section is the section of this bill that's in our jurisdiction, but I'm having a hard time placing the data privacy provision in the larger context when I really don't know what the bill is about. So is this, who are the applicants? Who's eligible? Is this just anybody? Is there any limit? What are we talking about here?
Senator Port, why don't you describe the bill in a little more detail that I
Sure.
think will help all of us understand.
Thank you, Mr. Chair. As you can see, the first section 1, subdivision 1 is definitions. If you go to 1.20, it talks about emergency rental assistance. And then that is described on 2.1 to 2.5. Those are examples of what emergency rental assistance can be used for. If you go to page, sorry, this is a new copy for me. I'm trying to find the right. In subdivision 3, it talks about how counties will get that aid out and who they should prioritize. This is not considered to be income as it pertains to applying for other state-sponsored programs, eligibility to those programs. And then there is reporting. And these are eligible households are listed in that subdivision 3. So or I guess maybe the easier place for you to see it, Senator Kroon, is in the definitions. Under eligible household, it lists very clearly who is eligible on pages 1.14 through 1.19.
Senator Kroon, any follow-up at this time?
Thank you, Mr. Chair. Sorry, I did not read this bill because it wasn't on our agenda. And so I'm working my way through it, so.
We'll take some time to do that, Senator
Yeah,
Kroon.
so I guess my question as it relates to the data privacy provision. Is there any, have you had any discussions with Minnesotans for Open Government or any data privacy advocates to help us to see if they have any comments? Were they notified that this bill was going to be in our committee today?
Senator Port.
Thank you, Mr. Chair. This provision is not new to the bill. We heard this bill in housing. We also heard it in taxes. I've had no outreach from anyone with concerns about this. This is similar to, this is the exact language that's used for other programs like this, including FHPAP and EA and EGA.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. And it may have been in the bill for a while, but this is the committee that we talk about data privacy, and this is the committee where people that have a care for data privacy come to talk about data privacy, not those other committees that you mentioned. So my question is did you notify them that this bill was going to be heard on an emergency basis with a couple hours notice so that they had an opportunity to come down here and provide input on the data privacy provision?
Senator Port.
No.
Members, we will note the bill was introduced February 17th, 2026.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. And you're saying that the data privacy provision was in this bill as introduced and that wasn't added in a committee? Is that what you're saying?
Thank you, Mr. Chair. It was added in a committee, but it has been discussed now in 2 different committees.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. Which committee was it added in and when was that committee?
Senator Port.
Thank you, Mr. Chair. This language was added in taxes this morning, and there have been discussions about data privacy throughout the course of this bill.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. So we have a data privacy provision added this morning in tax committee. We're hearing it a few hours later with no chance for the public that might be interested in this provision to provide input. That's what we're doing here today. I think this is just not the right way to make law. I just disagree with this fundamentally. This is just an improper legislative process. It's improper notice. It's improper to make good law and have the people here that we would normally be talking with about data privacy to not have notice of this and just expected to just figure out what's going on in tax committee and then figure out what might happen on the floor to immediately move it to judiciary and expect them to get here to test and look at the bill, testify in front of it is just not right, Mr. Chair.
Thank you. Senator Kroon, we'll keep that in mind next time an amendment is offered today without any, or in this committee, without any notice to anyone else that an amendment is coming. Senator Clark. Senator Clark passes. Senator Westlin.
Well, Mr. Chair, I don't want to have to coach you or preach to you, but you've been here long enough, and what you just said is completely 2 different paths that we have in custom and usage. Our rules don't say you have to have an amendment posted 3 days for an agenda item. We don't know what comes up in committee. So comparing an amendment process, unless you're telling us now that's going to be the new policy for the Judiciary Committee, is that what you're telling us, Mr. Chair?
We're not setting any new policies here today.
Okay, very good. Then don't make up a policy and tell Senator Kroon that that's going to be the new policy.
Senator
Because,
Westrom, are
Mr.
you
Chair, we are violating our Senate rules here today.
Senator Westrom?
And that is the bill we have in front of us. We should be hearing this with a 3-day notice. The rule says 3-day notice unless it's impracticable. We are only the 3rd week into this session. It is not impracticable. We don't have deadlines around the corner. Why are we rushing this bill through in hours after the tax committee added a data privacy provision to it? And it's got $40 million, as the author just told us, that you're going to try to shift in just a few hours by rushing it through committees and violating the Senate rules. Mr. Chair, I move to lay this bill on the table. We can bring it up next Monday. We can give proper notice to the parties, and we can follow the rules of the Senate in this committee. I move we lay this on the table and ask for a roll call.
Apparently Senator Westrom is done preaching to the chair, even though he said he wasn't going to preach. The motion to lay the bill on the table is not debatable. Roll call has been requested. Roll call will occur The clerk will take the roll.
Chair Latz.
No.
Vice Chair Uma Verbaeten.
No.
Senator Limmer. Senator Clark.
No.
Senator Holmstrom.
Yes.
Senator Kroon.
Yes.
Senator Pappas.
No.
Senator Seeberger.
No.
Senator Westlin.
Yes.
Westlin? No.
Senator Westrom.
Yes.
There being 4 in favor and 6 opposed, the motion is not approved. We still have Senate File 3596 before this committee. Is there any further discussion? Senator Limmer.
I want to bring our attention to page 5, line 5. I'll restate that with the microphone on. Bring your attention to page 5, line 5. There's a reference to settling litigation. Is that not an issue before the jurisdiction of this committee?
Senator Limmer, I'm advised that that reference has to do with the source of the funds that are being utilized in the expenditure proposed in this litigation, or in this bill, rather. There's no policy change or even being made with regard to litigation itself. It's simply referring to previous litigation that resulted in the corpus of funds being used here.
And Mr. Chair,
Senator Limmer.
in reference to the process, I understand in the other body this bill was considered, I think, in mid-February, and it failed to be re-referred to the Ways and Means Committee by a committee vote. That was over 2 weeks ago, so I still am trying to understand the emergency nature of the process. It just doesn't seem to be in existence. Thank you, Mr. Chair.
Well, Senator Limmer, as you well know, we don't define our Senate procedures by what happens in the other body. If we did, we'd have 2 dysfunctional bodies of the legislature instead of just 1. Senator Westrom? I'll leave that up to you to decide. Senator Pappas and then Senator Westrom.
Mr. Chairman, I just really want to urge the emergency nature. There are a lot of people who are waiting for this emergency rental assistance, and so I think it's appropriate that we move it forward as quickly as we can. I think the source of funding was very imaginative on the part of the chair, of the author, and I'm glad that you found that resource. But there are people who are being evicted, and that's certainly going to affect our courts, and also affect people who have no housing then, based on the situation that happened in the state over the last couple of months. So I would urge the committee to vote. Hopefully, we can still persuade the House to move forward with it and provide this very important assistance to families.
Senator Westrom.
Mr. Chair, just so the record reflects, I guess I'd like to know a few bits more of information. You, in response to the reason to bring this up and bypass the Senate rules that say 3-day notice to the extent practicable, is it your determination that this was impracticable to be able to hear in the process, so we had to pass on the 3-day notice to the public, or was that a decision made up above your head by your leadership and majority leader? I guess I'd like to know who decided that this was impracticable to post a 3-day notice, so we know what the new rule is going to be for deciding when bills get on the agenda without notice. Was that you or Senator Murphy?
Senator Westrom, as chair of the committee, I make the final decision as to what comes before this committee and when. So I will take responsibility with full justification. There are people facing eviction as we are having this hearing. because they cannot pay their rent. And we know that. As a matter of fact, based on the information Senator Port shared with us in her remarks about information coming in from the United Way and other sources. For a family facing eviction with children going out into the street where it's still below freezing at night, facing imminent homelessness, if that's not enough of an emergency for Senator Westrom or any other member of this committee, then I think we need a morals check on this committee. To me, that's plenty of emergency, and certainly falls within the
Chair.
Senate rules.
Don't we have a rule
Certainly
against?
falls within the Senate rules, which in my judgment, in my discretion as chair, I have the authority to evaluate and to bring this
Aren't
bill
we
before
prohibited
us
from
today.
impugning motives in this committee?
Senator Holmstrom, have you been recognized to speak?
Mr. Chair?
Senator Holmstrom, did you have something you want to say?
Yes, Mr. Chair.
What is it you'd like to say, Senator Holmstrom?
Don't we have Senate rules against impugning motives?
I'm glad you've learned from your first committee appearance, Senator Holmstrom. Yes, we do. And perhaps you will abide by the same rules for the rest of the committee that you serve on judiciary. Anything further from members of this committee?
Mr. Chair, I still have the floor.
Senator Westrom, you can talk to Senator Holmstrom, who interrupted you having the floor. But
He
there is
raised
no,
a point of order. He
by the
didn't say
way,
point of
Senator
order, which would be
Westrom,
the
there
correct way
is
to
no
interrupt, but-
concept of who has the floor in committee. But if you wish to have make further comment before I move on to Senator Westlin, who is next on our list, go ahead, Senator Westrom.
Well, Mr. Chair, I would just like to note the new standard that you are talking about right now can apply to every bill that has funding, and some of us deem an emergency, and that will be the new moral standard of the Judiciary Committee from what I just heard you say. So I'm glad you will treat everybody with fairness and objectiveness if that's the new standard, which will be a little hard to figure out the objectiveness from the subjectiveness, but your new standard is on the record. And if we're going to call it moral to not bring a bill up if there's people that could be harmed, that's the new standard for the judiciary. Mr. Chair, I've thought of you a lot more even-handed than that, than what we're seeing here today. I'm disgusted that in the third week of session, we've got over 8 or 9 weeks of the session, we've got committee deadlines several weeks away from us yet, and we're violating the rules because of the chair's decision and the DFL's decision to move this bill forward, pop it on the agenda without 3 days' notice, which is what the Senate rules do require. If it's so urgent, that should be discussed with the minority ahead of time, at least as a courtesy. But I don't think anybody on plain language of the bill, with all the other bills we also have to consider that will affect lots of people. If that's the new moral standard for violating the Senate rules, we've just heard it from you on the record. I think that's a wrong-headed direction to go for this committee, and I don't think it's becoming of how you usually try to run your committees. But I'm surprised to hear it. I'm flabbergasted, and I'm raising my point of concern that we are going to open a Pandora's box if this is the new standard, and I don't think this bill has to be rushed so fast through that we have to violate the 3-day notice, not give people a notice on the agenda, and a bill that's nearly dead in the House or probably is dead. So all of that should factor into the totality of the circumstances on the moral judgment that you've just set forth as a new standard in our committee. Thank you, Mr. Chair.
Senator Westrom, you're a lawyer. You're a careful parser of words. You know what the rule says, and yet you seem to ignore part of it. You know what I just said, yet you seem to ignore part of it. You're welcome to draw whatever conclusions you wish to draw. I'm the chair of the committee. I get to decide what is going to be heard and whether I believe there is an urgency that gets us within the exception of the 3-day rule. In my judgment, this bill meets that criteria, and I am certainly not going to make those decisions based solely upon whether the other body shares our concerns or our sense of urgency. Senator Westlin.
Thank you, Mr. Chair. I thought we'd actually talk about the provision that is under the jurisdiction of this committee, if that would be okay.
Senator Westlin.
Thank you, Mr. Chair. So my understanding is that what is being classified as private data on individuals, then according to this, is going to be data on applicants or eligible households that are collected or created will be designated private data, but it can be used to verify that an applicant is an eligible household. So who is it who would have access then to that data? And to your knowledge, or maybe this would be a question for Ms. Primo, are there other like classes of data similar to this that are also considered private?
Senator Port.
Thank you, Mr. Chair. Thank you for the question. As to who would have access to it, this will be run through counties. They are also able to use, if the county, as is the case in many greater Minnesota counties, they do not administer their own rental assistance on a regular basis because they don't have the staff to do it. And so they use an HRA or a local nonprofit, sometimes regional. And so those people who administer FHPAP currently are the allowable folks who can administer this program. They may have to check that eligibility with the counties to see if they qualify on those bases. To the other part of the question, if there are other blocks, that would be a Ms. Primo question.
Ms. Primo,
Senator
Mr.
Westlin.
Chair, I'm sorry, Mr. Chair. Mr. Chair and Ms. Primo, would this be similar, there are sort of analogous situations where similar data would be considered private?
Ms. Primo.
Mr. Chair and members, some of the data could be considered similar and analogous and likely captured by the by 13.46, which governs a lot of the sort of welfare system. That's how the term is used and defined in that statute, the welfare system data. So it somewhat depends on who is administering the data. I think Senator Port alluded to this, that in some counties, all of this data would be administered by the same groups who administer the data under 13.46, but in some counties, maybe that's not the case. And so that's when this statutory provision would apply.
Senator Westlin.
Mr. Chair, thank you, Ms. Primo. Thank you, Senator Port, for bringing this. I would agree that when we are dealing with the fact that there are not rental assistance funds currently available and we have people facing eviction presently, I would agree this is an emergent issue, but more specifically on the part that is under the jurisdiction of this committee, it seems like the data privacy carve-out here makes sense, and it would be similar to other classes of data. Thank you, Mr. Chair.
All right, members, I'm going to offer the 824 amendments. I'm going to hand the gavel off to the Vice Chair, Uma Verbatim. Madam Chair.
Senator Latz.
Madam Chair, the 824 amendment was distributed in the packets with the underlying bill, and I propose that we provide an extension on a temporary basis of the timeline or the notice provision for initiating eviction proceedings from the current statutory provision of 14 days to 30 days due to the unique nature of this provision and the unique urgency that's involved today that has created the overwhelming demand for rental assistance. I do not view this as a precedent for any more permanent changes in state law, and I would not support a change in state law on a permanent basis. But I do think that given the urgency that we are facing and the time that it will take for when this bill becomes law for the money to be made directly available to the landlords that would need to be paid for the rental units, I think we need to provide a little extra time there for the tenants to get these funds transmitted to the landlords and have the landlords delay the initiation of eviction proceedings for an additional 16 days then under current law. I note that it is temporary in Section B on line 1.10 for 4 months only. This extension would expire at the end of that time, and that 4-month period matches up with another provision in the bill that has the same timeline, so it's coherent in that regard. I ask for your support for this amendment, and I will stand for any questions.
Senator Port, I'll go to you first for your response to the amendment, and then we have some folks on the list.
Thank you very much. Thank you, Madam Chair. Thank you, Senator Latz, for offering this amendment. I think it's a really important piece of this puzzle. It does take bureaucracy of government some time. This bill has 14 days for DOR to get that money out to counties, and then counties will need to then turn it around for rental assistance. So this just opens up that that amount of time to give folks the ability to apply for this rental assistance, for it to get to counties so that they can begin to issue letters of that you do qualify and rental assistance is coming, or to send out the money to folks. It's a critical piece of making sure that we don't fall into this eviction crisis that we have looming in front of us. So I consider this a friendly amendment and hope you will consider it.
Thank you. Senator Clark.
Thank you, Chairwoman Baton. Thank you, Senator Latz, for the amendment. I agree. In talking with some of the folks who've worked through getting rent delinquency funds, they've talked about how the process is not 14 days. It's closer to 28 days. So especially when there's this big bolus of work coming through, it's may last even longer, but this will help get through the immediacy of the crisis. So thank you for the amendment.
Senator Kroon.
Oh, thank you, Madam Chair. I guess my question's not on this amendment, so I'll wait.
So Senator Latz has offered the A24 amendment. All those in favor say aye.
Aye.
Any opposed? The motion prevails and the amendment is adopted. And then to the bill as amended, I'll hand the gavel back to you, Senator Latz.
Senator Kroon.
Thank you, Mr. Chair. You know, when I brought up my concern about the timing and not having the data privacy people here or notify that, I think it was a legitimate concern. You know, I'm learning a lot about the Data Practices Act, but I'm certainly not an expert on it. And so it's really disappointing that you, Mr. Chair, would basically say that that's a moral position. I came at that in good faith. And so I do feel like you were questioning motives on that. But I just wanted to clear that up. I think having those data practices people here is helpful for the bill. And so I think that's, Minnesotans are kind of tired of politicians making every policy disagreement a question of morals all the time. I think we can do better than that and tone down the rhetoric. That's my statement, my question on this as I'm looking at it. And again, I'm not an expert on the Data Practices Act, but my question is, with all of this money going out, does this provision prevent, or is there any other mechanism for law enforcement or the Office of Legislative Audit or anybody to make sure that they have access to this data to prevent fraud?
Senator Port.
Thank you, Mr. Chair. Sorry. Yes, there are significant fraud prevention pieces in it. In the subdivision 8, you'll see that, let me find the line. It was added to go to the legislative auditor. It's on 4.26, that they will have access to the reporting from this. There is additional safeguards held through this that exist in our current emergency rental assistance programs that the providers of this program will use. These providers are accredited every year in order to ensure that they are, meeting all of the requirements of emergency rental assistance. There is extensive reporting that's required, both directly to the counties and then from the counties directly to us as well.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. I mean, a report going to the OLA isn't the same thing as giving them access to the actual data. And summary data in a report is not, I guess, what I'm getting at. I'm getting at is there anything in the data privacy provision here that would restrict authorities from making sure they have the actual data for eligibility to prevent fraud?
Senator Port.
Thank you, Mr. Chair. I will say I'm not an expert on what the OLA has access to. This is the same provision under which FHPAP data and many other of our programs are classified as non-public. I don't believe the OLA is considered a public entity, so I do believe that they have access if they need it for audit purposes. But I would defer to Ms. Primo, who drafted this language.
Ms. Primo.
Mr. Chair and members, this provision does not change whatever authority the OLA has to access non-public data for purposes of their various audits and reports. I am trying to find the provision in the OLA statute that gives them that authority, but I have not been able to find it yet.
Senator Kroon, any follow-up?
Thank you, Mr. Chair, and thank you, Ms. Primo. Again, I think that's why having the data privacy people here is important, because they can come up here and answer these questions and dig into that and understand the interplay between the Data Practices Act and some of the other statutes. Obviously, I won't go into all of my concerns about the potential for fraud here. I'll save that for, I guess, the Senate floor, but yeah, those are my comments. I won't repeat myself. Thank you, Mr. Chair.
Are there any other amendments to Senate File 3596? Senator Kroon, I do wish to respond to your comments, and I take your comments in good faith. And for clarity, I should have been more circumspect, saying for me this is a moral issue, and justified the urgency here. And I take to heart your comments, not to cast aspersions on the intentions of any other members, and I hope that your side of the aisle, including now departed Senator Westrom, will take that guidance to heart as well in future conversations. Any further discussion on Senate File 3596 before we give the author of the bill final comments? We do have further information from Ms. Primo. Ms. Primo.
Mr. Chair and members, I'm sorry for the delay. Section 3.978 subdivision 2 gives the OLA the authority to access data of any classifications. It's under their general sort of subpoena power as well, and their authority to access the data for any of their audits or reports or work that they do.
Does that raise any further questions from members of the committee? Not seeing any. Senator Clark, would you like to move the bill?
Happily, I move the bill.
Senator Clark moves that Senate File 3596 as amended be recommended to pass and be referred to the Senate Committee on Finance. All those in favor say aye. Aye. Opposed? Motion prevails. Members, we are adjourned. We are not having a hearing on Friday, members. We will meet again March 9th in this room, capital G15 at 12:30. Now we're adjourned.